so they're busy with catching up some sleep or something. But in any event, we have to start right now, and it gives me great pleasure to introduce the speakers this morning to run this particular session. And I also want to thank Michael Cooper for inviting me to attend to this particular panel session this morning. So, of course, this morning we're going to look at various aspects regarding existing initiatives within the field of international arbitration. There's, of course, the KJAC initiative. There are various other initiatives in China, in Africa, etc. And then, of course, we have a new role, not a new role player, but in the field of arbitration, we also have the BRICS initiative. So we will see how all these developments speak to each other and actually how they can actually complement each other. And we will hear from people who are deeply involved in various of these initiatives. So that is basically what today is all about, and in particular this session. So our first speaker this morning will be Michael Cooper, who's of course a senior counsel here in South Africa and here in Johannesburg. Now, Michael needs no further introduction. In particular, we know he's one of the most senior advocates in South Africa. He has a very long standing practice in commercial work, in arbitration, and is also deeply involved in various arbitration initiatives here in South Africa, in Africa, and in China. He's also, of course, the chairperson of AFSA. And I know Michael, and he has a real passion for this work that he is doing. So he will be our first speaker this morning, and I'm going to ask Michael to give us a sort of an introduction and to explain to us where we stand with KJAC on the one hand, and some of the aspects pertaining to BRICS. So, Michael, we're looking forward. Thank you very much.
Good morning, everyone. I want to talk to you this morning about the history of how it has happened that AFSA and indeed South Africa has become so firmly involved in the very exciting global arbitral initiatives and innovative changes, fundamental changes to the way that international arbitration has for generations been run and conducted and is now undergoing tremendous change. I can only tell you about it anecdotally, and the only reason I would justify telling it to you anecdotally is because there is no other way of telling you how it happened. AFSA, as you know, I hope, was established in 1996. And I want to say something about the state of knowledge in South Africa at the time regarding international arbitration and where we were in the international arbitration world. I want to give you a sense of how isolated we were, how little knowledge we had, how little involvement there was outside of the country itself, and particularly so in the arbitration movement. You would have thought the arbitration movement would be one of those movements that would have international connections, an international horizon, would be part and parcel of global arbitration. But that was not the case. In 1996, when AFSA was launched, There was, from the legislative point of view, there was the fact that South Africa had become a signatory to the New York Convention. But it had done no more than that. It had no legislation at all which dealt with international arbitration. It had an outdated, and today even more outdated, Arbitration Act, which was not intended to cover international matters and which was entirely local in its application. So the legislative element for international arbitration in South Africa was completely absent. The second element, the courts. The courts had dealt with almost no international arbitration matters of any importance. The arbitration centres. Well, AFSA in 1996 was the first arbitration centre to administer arbitrations. So again, there was nothing. And what was even more sad was that in South Africa there were no international arbitrators. Those practitioners who knew anything about international arbitration, if they wanted to pursue a career, left the country, and they went to places where they could practice as international arbitrators. And I'm talking about a handful of people in the whole country who, when they made those decisions, they left us. And therefore there was no institutional knowledge about international arbitration. So South Africa was a desert so far as our activities were concerned. And then, if it was possible to get worse, it did get worse. Because one day in AFSA, we were telephoned and told that AFSA had been selected to nominate an international arbitrator in a matter that was being administered by the ICC. So the ICC somehow found our telephone number and told us, would we please appoint an international arbitrator. So what did we do? We spoke to one or two of our emigres and said, well, who should we appoint? And they told us to appoint an outstanding member of the London Bar. So we said to the ICC, we AFSA, in our vast knowledge and experience of international arbitrations, have appointed so-and-so in the matter. And the ICC said, thank you, goodbye. And there followed the arbitration. And it was conducted properly by an eminent English arbitrator, and the arbitration went under the name, which now is a landmark in our law reports, Telkom and Telcordia. And the Chief Justice referred to it in passing yesterday. But he was very polite, because he referred to the Supreme Court of Appeal decision. He said nothing about the decision of the court below. The court below, sitting in Pretoria, took great offense at the fact that here was an Englishman purporting to understand and apply the Roman Dutch law, when of course only South Africans could possibly understand the Roman Dutch and English law in their amalgamated form. And so he sat and decided in effect that he would take this as an appeal against the finding of the judge and of the arbitrator. And he found all sorts of things had gone wrong. And so he decided he couldn't allow this nonsense to continue with an English arbitrator, and so he removed him. And he spoke to one or two of his chums, and he appointed, on his own bat, a South African arbitrator to take over. Now, all this rather upset the New Zealand company, which was the arbitrating claimant, and they had the gall to take it to the Supreme Court of Appeal. And the problem is this: the Supreme Court of Appeal gave a wonderful judgment. It was given by Louis Hurrens on behalf of the Supreme Court, and it is a decision that I would recommend you all look at if you can. It is a wonderful analysis of what went wrong and what the true precepts are of international arbitration. But it took a year or more before it got there. And in that year, South Africa's reputation as a possible arbitral venue was destroyed. The president of the ICC came to South Africa, spoke to me, and said to me, "We cannot recommend and will not recommend South Africa as a venue for international arbitration." And I want to tell you the Chief Justice again was completely correct when he said that it's the one bad judgment out of a court that stains the reputation of the country, irrespective of whether that was a judgment which was overturned or not. The negative judgment has a devastating effect. Let me tell you what kind of negative effect it had. One of the Africa Union banks, continental banks, decided that it was time to identify centers in Africa that could handle international matters. So did they ask an African to go into the question of where there would be a suitable African center? No. They did what governments did at that time in Africa. They sought the expertise of Europe. And in due course, a Swiss attorney and an Austrian attorney went into the question of where in Africa should there be an arbitration center. And so these two, steeped in their knowledge of Africa, which I believe was nil, had a glorious tour of Africa. And they told us they were coming to South Africa. And so you can imagine our excitement. We called a meeting of all our leading arbitrators. We laid on a tremendous feast. We gave them a bribe. We offered them drinks. And we said to them, "Here is AFSA. Here is the arbitration center of the future in Africa. Come and meet us." And they did. And they were very pleasant. They then wrote a report in which, in regard to AFSA and South Africa, they said not one word. In their opinion, there was only one possible center, and that was Tunisia. Now, I've often wondered over the years, how did they get to Tunisia? And then it struck me it was probably the closest to Europe. And so if they were in fact going to run the center from Europe, why should they trek down all of Africa? Of course, it was just before the spring of the Arab Spring in Tunisia, but nonetheless. So everything was negative. Europe turned its face. There was no relationships anywhere until 2013. There came a knock on the door. The knock on the door came from the China Law Society. A man suddenly appeared and said he would like to get to know something about AFSA and South Africa. And that initiated the beginnings of what has become the fundamentally important associations which AFSA now has. Because from then on, there were meetings with representatives of the China Law Society. And you will recollect that this was about the time that President Xi Jinping was announcing the Belt and Road Initiative. The contacts continued through 2014, and then they invited a delegation from AFSA to go to China and to meet the Law Society and other people in China who were developing some kind of concept to deal with the growing business and investment between China and Africa. They knew some kind of dispute resolution mechanism was going to be required, but they had no concept of how that would best work. And so they were reaching out, and their recommendations apparently from the Chinese universities had been to make contact with AFSA. In 2015, a party of AFSA delegates went to Beijing, went to Shanghai, in the first phase of creating that mechanism. And it resulted in the issue of a document called the Beijing Consensus. And the Beijing Consensus reflected the joint understanding of the signatory parties to the idea and to subscribe to the idea of creating that mechanism. And indeed, there was an important intergovernmental decision behind that. The FOCAC, the Forum of China-Africa Cooperation, representing almost every single African government and the government of China, called into existence an arbitral mechanism for the purpose of resolving disputes between China and Africa. We proposed that it should be by way of a partnership between African centers and Chinese centers. We said, in our view, that was the only way in which ultimately there could be an empathy between China and Africa business communities, each having confidence in a shared panel of arbitrators working under common rules. And that was the concept that was accepted, and that was the concept that was used to plan the KJAC project. And we swapped wisdom with our new partners in Shanghai and Beijing and Shenzhen. We heard from them that a great journey starts with a single step. And we thought that was, as it is, profound. And we said to them, "Do you know how to eat an elephant?" And they said, "No." And we said, "Piece by piece." And so the mutual exchange of goodwill and wisdom came. And we called a meeting of all our founder members in Johannesburg. And we said, we've been having these initiatives from China, and what are we going to do? And at that time, there was very little knowledge about China, and there was very little knowledge about anything outside South Africa. but there was an understanding that here was a continent offering a handshake across the world with us. And this, as I've explained, was at a time when Europe in particular had formed a very negative view about South Africa. And so we concentrated on developing this relationship, and we met our partners, and we were so impressed by their goodwill, by their cooperation, by their efficiency, and we stood amazed at the scale on which they worked. We were proud to have 150 matters in a year. We were talking to organizations like SHIAC and Beijing and SKIA, who dealt in the thousands. We sat in a couple of offices as AFSA, and we were looking at centers that occupied buildings, skyscrapers, quite amazing. I've never regretted for a moment the commitment that was mutually made between ourselves and our Chinese partners, and then our African partners in Nairobi and in Ohada. It was a dynamic step leading to the growth in South Africa of an international understanding, an international perspective. And what then happens? We say to our partners, well, let's draw up the rules. Should be easy enough. Until we started actually trying to do the job. And we had to create a set of rules that would be accepted and enforced by the People's Court, and that would be accepted and enforced by the jurisdictions and courts in Africa. And we soon realized that we needed someone cleverer than we were to sort that out. And so we turned to David Butler, and we said to David, do what no one has done before you, go and create a set of rules that will be acceptable, viable, practical, and will be enforced by the courts of China and the courts of Africa. And David will tell you in a moment how difficult it may have been, how easy it was for him. Lindy will tell you about BRICS. She has led our delegations in BRICS, and it is a tribute to David's work that BRICS have, the BRICS legal centers, arbitration centers, have adopted the KJAC rules as the first set of rules to be adopted and adapted for the particular BRICS initiative. And then we're going to ask a very eminent representative of our partners in SHIAC, Dr. Dew, to talk to us about what Shanghai has done in BRICS. And in talking to us about what Shanghai is doing in BRICS, to talk to us about the first BRICS center that is being created through SHIAC. Can I take just this last moment to say to you that our involvement with China has not only been with our partners in KJAC. Resulting from that partnership, we have been involved in dealings with other major Chinese arbitration stakeholders. Confusingly, they tend to be known by their initials. One of them is ICD Paso, whose involvement in the Belt and Road Initiative is very pronounced, who are dispute resolution theorists and experts, both in dispute avoidance and dispute resolution, with members through the world. AFSA has the privilege of being an executive member. It is one of two members of ICD-PASO, the other being the African Union. We're going to play after the next session a message of congratulations and friendship from ICD-PASO to this conference. It runs for about 4.5 minutes, and we're going to play it just as the tea break intervenes. I would invite you just to listen for 4.5 minutes. Thank you.
Thank you very much, Michael, for setting the scene and also the explaining the important role that AFSA played in setting up various structures to take this whole initiative forward. Thank you very much. So our next speaker will be David Butler. David is an emeritus professor at the University of Stellenbosch. He's also a research fellow still at the law faculty at the University of Stellenbosch. And David is an eminent academic in South Africa. He works in various areas in commercial law, and he has also taken up arbitration as one of his areas of speciality. And he was involved with the South African Law Reform Commission to pave the way for establishing our own International Arbitration Act of 2017. So David has been working in various areas in arbitration. He's also deeply involved in the work of AFSA. And David got this daunting task to establish rules that would be acceptable to China as well as to Africa for arbitration. And I guess it's a little bit like establishing rules of engagement when you get deeply involved in the relationship with a foreigner. And that was the daunting task that was handed over to David. So David, we are looking forward to your session to explain to us the difficulties in bridging these gaps between various jurisdictions, various expectations, etc. So please, David Butler.
Chairperson, firstly, thank you for your very kind and generous introduction. It is a great privilege to me to be asked to speak at this inaugural JAW and to speak after the person who can rightly be regarded as the father of administered arbitration in this country. As Michael has just mentioned, AFSA was established in 1996. The road has not been an easy one, as clearly appeared from Michael's address, but without his vision and determination, AFSA would not have been in the place that it occupies today. Now, basically, my task is to explain to you how the drafters of the KJAC rules set about bridging the jurisprudential gaps. And I'm going to do this not by going blow by blow through the KJAC rules. They are available on the KJAC website and can be read, but I'm going to show you certain characteristics of the rules that demonstrate how two opposing arbitration cultures, in a way, were brought together. Now, I'm going to do this first by way of an introduction. I will then turn to the principal methods of curbing costs and saving time in arbitration, the Chinese perspective being that Western methods of arbitration are just far too slow and far too expensive. And then I will look at the adaptations that it was necessary to make in the KJAC rules to accommodate the sensitivities of parties from Africa, particularly from model law jurisdictions, bearing in mind, as we've heard at this conference, that there are now 13 parties in Africa that have the model law, as to be rather opposed to ad hoc arbitration. And both Chinese and African users would be comfortable with this fully administered arbitration service. And that appears from the KJAC rules, Article 1.1. Now, African parties in this post-colonial era have mainly conducted arbitrations under rules, particularly international arbitrations, cross-border arbitrations, on rules that have been drafted along what one could call Western lines. There is no shame in this, in that the joint largest arbitration center in the world today, Singapore, next to London, Singapore's rules, whatever else one may say about them, have a clearly Western stamp in their format and provisions. Now, AFSA's cutting-edge international arbitration rules, to which quite a lot of attention has rightly been paid at this conference, are also drafted accordingly. Now, mainland China, commencing with SEATAC, has developed its own distinct brand of international commercial arbitration. More recently, the major industrial cities in China, including Beijing, Shanghai, and Shenzhen, have formed their own arbitration centers distinct from SEATAC. And our 3 Chinese associates or partners have joined with us at AFSA and also our 2 other African parties in forming KJAC. Now, KJAC Johannesburg, which is established and maintained by AFSA, was given the task of preparing a set of KJAC standard arbitration rules in the latter part of 2018. And in the latter part of 2019, the initial draft of these rules was refined at a joint meeting between the 3 Chinese KJAC associates and AFSA held in Shanghai in China. And this draft was further refined by means of email exchanges with inputs from all 6 associates. And by the time that the initiative started, all 3 of our Chinese associates had their own international commercial arbitration rules, which were, of course, aligned to the Chinese arbitration law. So it was decided by AFSA Johannesburg, tasked with preparing the initial draft of these rules, that we should take the rules of the Shenzhen Court of International Arbitration, SEAC, of 2016, which were at the time the most recent of the rules of our Chinese partners, and then to take those as a point of departure. I may say that all 3 of our Chinese associates have since introduced updated rules, but a comparison between these rules and KJAC shows that the KJAC standard rules, which I will explain in a moment, have weathered well. It is also important to bear in mind that the People's Republic of China is in the process of reforming its arbitration law. and this will have an impact on the rules used by Chinese arbitration bodies. The aspects of the reform are controversial, and there is a few political landmines to get around, and so the process is not going to be an overnight event, it would seem. Now, if one looks at the CAJAC rules, they start with Chapter 1, which contains certain general provisions, particularly regarding the jurisdiction of CAJAC centers in Article 2, and then Article 3 regarding the scope of application of the rules. And Article 5, dealing with the language of the arbitration, as you would expect, pays deference to the principle of party autonomy. So the parties are free to choose the language in which the arbitration will be conducted, and if there is no choice by the parties on its appointment, this matter will be left to the arbitral tribunal. Now, turning to the features of the CAJAC rules, which were incorporated to make sure that the rules would be acceptable to Chinese parties, these are distinctive features compared to what one may loosely call Western-style arbitration rules, and they are particularly directed at curbing costs and saving time. But I would emphasize that although there is a stress on keeping down costs and saving time, the fairness of the procedure and the justice of the award has to be beyond reproach. That is also one of the aims, obviously. Now, the structure of the CAJAC rules closely follows the SIAC rules, the rules of the Shenzhen Center of 2016. And one of the key points of difference with the rules that we as South African and African lawyers are accustomed to concerns the determination of the issues in dispute and the exchange of written evidence. And the Chinese perception is that the Western procedure for defining the issues in dispute just takes too much time, and in the end, time is money. Now, in a two-party dispute, we'll deal with or mention multi-party disputes very briefly just now, but in a two-party dispute, the rules require that the cases of both parties are contained, in the case of the claimant, in the request for arbitration under Article 10, and then the statement of defense is in Article 13. And these set out not only the facts which the party will attempt to prove, but also the legal arguments of its case. And so at the outset, both parties are required to put all their cards on the table. And this, of course, compared with the traditional Western way of defining the issues in dispute, does save a lot of time, but it does mean that additional expense has to be incurred up front. Another feature of the CAJAC rules, which would appear as strange to parties from Africa, is the provision for expert reports. Now, all modern arbitration rules give the arbitral tribunal the power to appoint experts, but they will typically also make it clear that the parties are allowed to appoint their own experts. And surveys of arbitration users have shown that in the West and in Africa, and the preference is very much to use party-appointed experts rather than tribunal-appointed experts. This was briefly dealt with in a panel yesterday afternoon in which I had the privilege of contributing. Now, what is immediately striking about Article 42 is that the tribunal, under the CAJAC rules, in consultation with the parties, may appoint experts. There is absolutely no reference in the rules to the possibility of the parties appointing experts, and this is a way of discouraging that. Now, basically, as one would expect, the tribunal can consult with the parties, and the tribunal may even allow the parties to appoint the tribunal, or rather nominate the tribunal-appointed experts jointly, if that is possible. Then the tribunal expert will prepare a report based on information provided by the parties, and there is also provision for an optional oral hearing where the parties would have the opportunity to question the expert about the report. I should also make it clear that this expert is there to assist the tribunal in understanding the factual evidence, and the role of the expert is not to become the fourth arbitrator or even the dominant arbitrator on the tribunal. The expert is not a member of the tribunal. Now, a trend in Western-style rules, including the AFSA international rules, has been in recent years to make provision for so-called expedited arbitration, where an attempt is made to make sure that the process operates more swiftly. And these expedited rules are contained in the CAJAC rules, and Articles 53 to 59 are comparable with the ICC expedited rules or the AFSA international arbitration rules. Now, one of the challenges for drafters of expedited rules is how does one incorporate various provisions of the standard rules, the normal process, so that the expedited rules are kept relatively brief. And this has been done in Article 59, which explains that the relevant provisions in the other chapters of the rules shall apply to matters not covered by this chapter. Now, the chapter on expedited rules itself, basically, it was decided that the CAJAC rules should work or use the working currency of Africa, namely the US dollar, and therefore the expedited rules in principle apply to disputes where less than $1 million is in dispute, and the parties may, of course, agree to apply the expedited rules to disputes that are larger, but the rules are not really intended for complex disputes. Now, Expedited in the context of the rules definitely means expedited. Normally, under the standard KJAC rules, the defendant in the arbitration has 30 days, which is not a long time, but 30 days for its statement of defense. This is now cut to 20 days. Normally, in the standard KJAC arbitration, the tribunal is expected to make its final award within 6 months of its appointment, which would be fast by the standards applied by arbitral institutions in Africa and in the Western world. Now, the time for the award is now, in terms of Article 47.3, reduced to 3 months from the appointment of the tribunal, normally a sole arbitrator, unless the time is extended. Now, there are also 2 features regarding awards which justify brief mention. The first is Article 51, and that deals with the scrutiny of the draft award. And this is clearly based on the provision of the ICC rules, and it is also reconcilable with the enhanced role of the arbitration center in Chinese-style arbitration. So, as one would expect, following the ICC practice, the center in its scrutiny may make suggestions regarding, or it may prescribe corrections of formal errors in the award, and it may make suggestions regarding reconsideration by the tribunal of some of the substantive aspects. But there is a difference between the formal corrections, where the center can require these to be made, and changes to the substance, which are a matter for the tribunal, and the center cannot prescribe here. Now, as with the AFSA international rules, what happens when there is no majority? You have a panel of 3 arbitrators, but regarding their award on the merits, there is no majority. Well, these rules, the KJAC rules, follow the AFSA rules and certain other rules by giving the presiding arbitrator the power then to make the award on behalf of the tribunal. Now, to close on this brief overview of the provisions in the rules to accommodate Chinese practices, it's worth referring to Appendix B of the KJAC rules, which contains the schedules of arbitral fees, the charges of the institution, and the fees of the arbitrators expressed in US dollars. Now, these fees in both cases are calculated in accordance with the amount in dispute. Now, if one compares these rules with the AFSA international rules, one will see that the fees of AFSA international, also calculated in US dollars, are calculated according to the amount in dispute. And I can mention that the AFSA international fees, although calculated in US dollars, are a little bit cheaper, less expensive than the KJAC rules. However, the column on arbitrators' fees that you will find in the KJAC rules is conspicuously absent in the AFSA schedule or Annex 3. And that is because African arbitrators tend to work on an hourly rate or a daily rate. So, whereas the CAJAC rules control the fees that arbitrators are entitled to, there is no such provision in the AFSA rules as they stand. Now, this should be a way of marketing CAJAC, and from the perspective of African arbitrators invited to take appointments in CAJAC arbitrations, there is also honor at stake. It will look good on one's CV if one can say that one has been in a CAJAC arbitration as arbitrator. Now, what adaptations were made to accommodate model law jurisdictions? In the first place, Articles 8 and 9 accommodate Article 16 of the model law. The principle of severability is described fairly comprehensively in Article 8, but Article 9 is rather more ambivalent on the principle of competence. And it is stated that the centre can determine, the CAJAC centre can determine whether the arbitrator has jurisdiction, and it may delegate this to the tribunal, which is a rather watered-down version of the principle of Article 16 of the model law. But in model law jurisdictions, one could at least make out a case that Article 16(1) is mandatory and should therefore be given effect to. Now, the standard rules of CAJAC apply wherever the arbitration is being held, whether it has its seat in China or its seat somewhere in Africa. But there are two examples, main examples, where local rules apply, and this indicates areas where the Chinese approach is fundamentally different from that provided in model law jurisdictions. And by way of example, interim measures may be granted by arbitration tribunals under the model law, and Western-style rules typically also provide for the appointment of an emergency arbitrator. The Chinese practice is to allow arbitrators to become involved as mediators during the arbitration process, and that is dealt with in the SIAC rules, for example. Now, the South African version of the model law has very little to say on this issue. That's not because the drafters of the model law wanted to outlaw the possibility of the same person being mediator and arbitrator, but if the parties want that, they must arrange it themselves. We were also anxious to avoid the mediation community descending on us with lots of comments that could delay the passage of the Act when it eventually got to Parliament in 2017, some 20 years after work started on it. Now, the law applicable to the merits, as you would expect, this is a matter for the parties and then the tribunal. It's also important under the model law that an arbitrator can only apply equitable principles as opposed to rules of law if expressly authorized by the parties. And although the CAJAC rules are silent on this point, and deliberately so, in my contention, Articles 28, 3 and 4 of the model law would apply. Now, the Chinese rules use the term interlocutory award for what we would call a procedural order. And in the context of the KJAC rules, this distinction is particularly important, bearing in mind that an award is subject to scrutiny by the Centre. So the procedural orders of the tribunal are not subject to scrutiny. Now, by way of concluding comment, I would just say that the multi-party arbitrations are increasingly common in practice in international arbitrations, and the KJAC rules deal with these in Articles 16 to 19. And I can give you the assurance that the rules contain no hidden surprises or traps, and that they are largely based on the consent of all the parties would be required. And that is a principle that is well accepted by African parties and by Chinese parties in this context. Thank you very much for your patience.
Thank you very much, David, for introducing some of us to this very intricate rules. And it's, of course, it must have been a very difficult task to work out these rules. But I think what you have achieved is to establish a firm platform for taking this whole international initiative forward. And I think whoever wants to work in this particular field will definitely have to take a serious look at the rules that are already in place. So thank you very much. So our next speaker will be Lindy Nkosi Thomas. She's a senior advocate here in Johannesburg. She practices in commercial law, constitutional law, and administrative law. She's also deeply involved in arbitration. She's the vice chair of AFSA. She's also a member of SHIAC, and very importantly for our discussion now is she's also the chairperson of the BRICS initiative on international arbitration, dealing with the South African chapter. So, Lindy, please inform us about the latest information. Give us the status report on what's happening from the BRICS side. Thank you very much.
Thank you, Professor Bahrain, for your very kind introduction. Good morning, ladies and gentlemen. It's a great pleasure and an honor to stand before you this morning and share some thoughts on the BRICS Alternative Dispute Resolution Mechanism initiative, that is, AFUD. By way of introduction, the BRICS member states comprise a population, a world population of 45%. And here, one should pause to just remind us that there has since been the accession of 5 states into the former 5 BRICS. As it were, it used to be 5 states, and now, since 1st January 2024, based on the invitation, the group has since grown. So 45% of the world population, 30% of the world GDP, and 17% of world trade. It is anticipated that by 2030, the BRICS countries will account for over 50% of global GDP. In that context, colleagues, it becomes inevitable that with that growing commercial activity, intra-BRICS dispute will inevitably arise. I will confine my discussion for the moment to international commercial disputes, and I'll touch on investment disputes later on. Now, when that happens, given the disparity of the member states within the bloc in the way of the legal systems, the cultural inclinations, linguistic differences, it is necessary to find a uniform and harmonized dispute resolution mechanism. It was with that realization in mind that the BRICS Legal Forum, which is a forum that meets on an annual basis, it follows the summit, wherever the summit gets hosted. The BRICS Legal Forum similarly gets hosted there. South Africa hosted the legal forum, the BRICS Legal Forum, last year in December 2023. So the Moscow Declaration, perhaps I should backtrack and say, at those BRICS Legal Fora, at the end of such a forum, we would then adopt a declaration which would set out what we set out to achieve in the ensuing years. Now, in 2017, at the BRICS Legal Forum that was held in Moscow, it was decided, realizing this very crucial harmonization need, that the member states should each establish a BRICS arbitration center. And 2017, of course, that would have been before the accession into the BRICS bloc by the other 5 countries that joined in January of this year. So, based on that declaration, the Moscow Declaration, the 5 member states established their centers. In China, Shanghai International Arbitration Center was designated as a BRICS arbitration center. In South Africa, AFSA, the Arbitration Foundation of Southern Africa, was so designated. In Russia, the Arbitration Center of Russian Union was also established. India similarly established, and Brazil did the same. Now it remains for the new entries to follow suit and establish their centers. Now that having completed the work of designating the centers, certain practical steps have to be taken to get the centers live, i.e. to get the centers active to deal with the dispute resolution assignment that they have. Question is, what requires to be done? Last year, at the BRICS Legal Forum that was held in Johannesburg, it was decided amongst the many declarations that were adopted that the rules that Professor Butler has meticulously taken us through will be used as a foundation for the rules that will be adopted by the various centers. The idea there is that we shouldn't have to reinvent the wheel, and quite obviously, the rules will have to be modified and adapted to fit the specific requirements of the BRICS member states. But we, as AFSA, are delighted to be trailblazing in that manner and relying, as we would be, on the work championed by both Michael and Professor Butler in the design of the rules for the BRICS arbitration centers. Now, that's where we are on the commercial arbitration side. Now, the question that remains is, what about investment arbitration? Would those centers be equipped to deal with investment disputes? What about the bids that are in place? What is the approach going to be there? There are complex considerations when it comes to that aspect of the work. But we, as the practitioners involved in the design of the mechanism, are acutely aware of that challenge and the complexities that it poses, and accept that laying down the framework for commercial arbitrations will serve as a basis upon which to build in relation to investment disputes. There are issues of sovereignty that arise in that regard, issues of equal treatment of investors, issues of reciprocity, and so on and so on. So those issues have yet to be considered by the team that is working on the mechanism. But I'm confident that we will get to a point ultimately where we have a mechanism that is acceptable to all the practitioners practicing within the bloc. Thank you.
Thank you so much, Lindy. And we now come to the last presentation during this first session this morning, and it's my privilege to introduce to you Dr. Dorian Du from China, from Shanghai in particular. And she has an interesting collection of qualifications. I saw that she graduated in English linguistics and literature. She holds a master's in political science, and she also holds a doctorate in legal history, so quite a collection of qualifications. Now, Dorian, if I may, is involved in quite a number of international commercial bodies, etc., in China, but currently she's the head of public relations of the Shanghai International Arbitration Center, SHIAC. And she's going to inform us about the SHIAC initiative, the SHIAC Center, and also how it may tie in with the BRICS initiative. So thank you very much, and welcome to South Africa. Please.
Thank you, Andre, and distinguished guests, ladies and gentlemen, good morning. First of all, on behalf of Shanghai International Arbitration Center, SHIAC, I would like to express my sincere gratitude to for the invitation from the organizers of today's meeting. I'm very pleased to have this opportunity to look forward to the future development of the BRICS arbitration mechanism together with all of you here. Today, I would like to make two aspects of sharing. First of all, I will introduce some explorations and practices of the BRICS Dispute Resolution Shanghai Center. And second, I'd like to make some prospects for the future. Under the guidance of the China Law Society, the BRICS Dispute Resolution Shanghai Center was established during the second BRICS Legal Forum. This center serves as an important work platform for SHIAC to undertake arbitration and carry out diverse dispute resolution mechanisms among the BRICS countries. As the first center established by the BRICS countries in October 2015, we have explored the BRICS countries' arbitration cooperation mechanism in several aspects. First, we established the committee's working mechanism. We have an expert committee composed of 23 Chinese and foreign legal professionals. In addition to the representatives from China's judiciary, arbitration, academia, and the legal profession, it also includes representatives from the Brazilian Bar Association, the Russian Federal Notary Association, the Indian Bar Association, and of course, OFSA. Through the mechanism of holding irregular meetings, it provides guidance and guarantee for the good operation of the center. And second, we widely attract experts from the BRICS countries to become arbitrators. After 2015, the SHIAC has carried out 2 changes of arbitrators and 3 additional appointments of arbitrators. The existing panel of arbitrators of SHIAC has a total of 1,463 arbitrators from 80 countries and regions, with 382 foreign and Hong Kong, Macau, and Taiwan region arbitrators, accounting for 26% of the total. Among them, there are a total of 33 arbitrators from countries outside China in the BRICS. Specifically, there are 11 arbitrators from South Africa, and 3 from India, 4 from Russia, 5 from Brazil, 3 from Egypt, 1 from the UAE, and 6 from Iran, which provides more optional candidates of arbitrators for the parties of the BRICS countries to conduct arbitration through the Shanghai Center. And third, we formulate arbitration rules that integrate Chinese and Western arbitration cultures. From the experience of the Chinese arbitration compared with the mainstream arbitration by the arbitrators in the West, it is more suitable for the BRICS countries to adopt the institutional arbitration model, which relies more on case procedure management offered by professional arbitration institutions to help realize the parties' autonomy and assist the tribunal to promote the arbitration procedure within a certain regulatory framework. SHIAC revised the new version of the arbitration rules in 2024. Bearing in mind that the party-oriented concept is the greatest common divisor of today's international arbitration, we further clarified the relationship and responsibility among the parties, the tribunals, as well as the institutions, and make a better coordination and integration of the 3. For example, we once accepted a construction project case, contract case, where the party submitted to SHIAC and agreed to apply the en situ arbitration rules for arbitration. The applicant is a R&D center established by a top 500 company in China, and the respondent is a private construction company in the Jiangsu province. This case reflects the Trinity case management concept, that is, for those that are stipulated in the en situ rules and do not conflict with the Chinese arbitration system, such as the generation of arbitrators by the panel, and the fact that the arbitrators can quote for remuneration separately. They all follow the parties' agreement. And for those which the en situ rules do not stipulate, but that the arbitration tribunal has the right to carry out according to the Chinese arbitration law, such as organizing mediation, the tribunal is encouraged to fully exercise its right. For matters that en situ rules do not stipulate but need to be fulfilled by the arbitration institution according to the Chinese arbitration law, such as the review and issuance of the award and the procedure order, it is the institution that fulfills the management responsibilities. The institution can also offer services for matters that are not clearly stipulated in both the en situ rules and the Chinese arbitration legal system, but can be assisted by the arbitration institution, such as providing the venue for hearing, providing secretarial services, and fee deposit services, etc. It is precisely because we adopt such a management concept of openness and integration that we are able to handle many cases in the past that apply international procedure rules, procedure soft law, and substantive rules for arbitration, including applying the arbitration chapter of the International Cotton Association, the rules of the Grain and Feed Association, the ISDA Master Agreement rules, URDG 458, etc. And therefore, our 2024 version of the arbitration rules officially integrates such a trinity management concept into the practice of the rules. And the fourth point is to make full use of the digital technology to improve the quality and efficiency of the case management. After the COVID-19 pandemic, international commercial transactions have entered the digital phase. And the needs of commercial subjects have also driven the digital transformation of international arbitration, especially in the BRICS countries, have shown a huge late mover advantage in the digital trade. In May 2023, our digital intelligence e-platform officially began to operate. Using cloud computing, artificial intelligence, and internet technology to connect online processes, improve the level of case management, and innovate service supply. At present, more than 5,000 cases are being conducted through the e-platform to carry out arbitration process. And the registered users include 722 arbitrators and 5,816 parties. From the perspective of the arbitration institution, the 2024 version of the arbitration rules stipulates that the parties can negotiate and agree, and the arbitration tribunal can also decide to carry out all or part of the arbitration process through the e-platform, and encourage the tribunal to adopt a green way to conduct arbitration. The parties can give priority to submitting materials and delivering them through electronic means. At the same time, we also release the online arbitration guidelines, the instruction for using the e-platform, the online hearing confidentiality statement, and the statement on the processing of personal information of the users of the dispute resolution services, among which the statement is the first compliance document of its kind by an arbitration institution in China. And second, I would like to talk about something on the future, on the arbitration cooperation mechanism for the BRICS countries. The BRICS Dispute Resolution Shanghai Center has made the initial exploration in the field of BRICS international arbitration collaboration and resource sharing. Yesterday, I represented KJAC Shanghai and discussed with other KJAC members on the future development path of the China-African Joint Arbitration Center. In fact, the work that has been carried out by KJAC can also provide reference for the comprehensive construction of the dispute resolution mechanism of the BRICS. Taking this opportunity, I also want to put forward some outlooks on the future developments of BRICS arbitration cooperation mechanism. First of all, the purpose of constructing the cooperation mechanism of the BRICS commercial arbitration is to create a regional community of commercial arbitration and achieve the coordination and the unity in the field of arbitration legal services among all members. Under such a concept, the cooperation of BRICS commercial arbitration should rely on joint discussing, joint building, and joint sharing. High-quality arbitration institutions of the BRICS countries shall be actively encouraged to become the new subcenters for the BRICS dispute resolution. Meanwhile, we shall do more to promote the optimal integration of arbitration legal services, meet the needs of diverse cultures and the legal concepts among the BRICS countries, and enhance the efficiency of arbitration as well as the credibility of the arbitral awards. Secondly, we shall absorb excellent arbitrators and legal professionals who are well-versed in laws, cultures, and arbitration practices of the BRICS countries into each BRICS Center panel, and encourage and coordinate legal service institutions of various countries to provide related supporting services for arbitration, such as offering hearing venues, translation, and recording. And thirdly, the construction of the arbitration cooperation mechanism should serve as an external force, driving force, to facilitate the joint formulation of cooperation agreements and model arbitration rules by the BRICS countries, which can meet the actual needs of economic and trade flows among the BRICS countries and respond to the new trend in international development. By unifying the standards of commercial arbitration among members, we can better meet the needs of the development of regional economic integration and create a community of commercial arbitration for the BRICS countries. Ladies and gentlemen, we are standing at the tip of the changing waves of historical trends. The full cooperation among the BRICS countries will generate tremendous energy to change the entire world. Without accumulating every small step, one cannot travel far. A unified dispute resolution mechanism of the BRICS countries can play a positive escorting role in the economic and trade exchanges between the commercial entities of the BRICS countries. Such a unified mechanism requires a hand-in-hand cooperation of our legal and arbitration circles. SHIAC, we are willing to work with everyone here to be committed to the construction of a unified dispute resolution mechanism for the BRICS countries. Thank you all.
Thank you very much, Dorian, for giving us this important information. And this brings to an end the presentations of this particular session. Now, we heard quite a lot of background information, where AFSA fits into all of this, various centers that are working in the field, and then, of course, also the important coming about of the KJAC rules and the difficulties in establishing these rules. I think suffice to say is that there are already quite a number of initiatives going, and I think it will be very wise for whatever route these various bodies take, that they look at what they have before trying to reinvent the wheel. So that is one aspect that I can put on the table. But unfortunately, we started a little bit late this morning, and there will not be time for questions and answers now in an attempt to try and catch up. So I think the best will be if you have any questions that you meet with the speakers of this panel during the tea break, and put your questions to them at that particular time. Dr. Du also indicated that she will make a full paper available to the organizers of this event. So thank you very much for that. So finally, from my side, thank you very much, and let's give a last round of applause to the speakers. Thank you very much. Oh, sorry, Dorian. I want to take a photo.
Jack Wolferis. I'm a partner at Clifford Hoffmeyer. We are a law firm based in Johannesburg, South Africa, our head office, but we have several offices in South Africa and in Kenya, and have several relationship firms also on the continent. I'm also the sector head for our firms industrial manufacturing and trade sector, and that obviously fits into our discussion today also in respect of BRICS, and in particular the December 2003 resolution. And we specifically refer to the December 2003 resolution because that's the BRICS Legal Forum resolution as opposed to the BRICS Summit, which was the August declarations by the heads of state, and how legal practitioners and other professionals will be able to assist the BRICS states to be able to achieve the objective set out in the declaration. So with that said, obviously I'm joined with an esteemed panelist, global panelists from all over the world. Some of them are here, some of them are in India, and some are also South Africa in Durban. So we are all over the continent and all over the globe in bringing together this panel for you. Now, the panelists for this session consist of, and I'm going to start not in a particular order, but we start with Dr. Seamus Dugant, Director of Global Risk for Control Risk, so they're also one of the sponsors, and maybe just a brief introduction to him. He's based in South Africa, provides geopolitical, operational, and security analysis for Europe, Middle East, and Africa. He also heads up Control Risk Tactical Intelligence Practice in the East Africa, Middle East region, which is focused on providing daily operational support to clients in complex environments. So Seamus, from Control Risk's perspective, will provide some geopolitical context between the global south and also the west in terms of where we're going, what do we see happening, and what is the ultimate importance of BRICS for the global south. And in India, we'll be joined by Mr. Prashant Kumar. He's joining us online. He's the president for the Bar Association of India and the Indian Law Foundation. So just a brief preview of Mr. Kumar. He's an economist, a lawyer, turned lawyer, so very interesting. He has been practicing as an advocate in the India bar for almost several years at the Supreme Court of India, the High Court, and specialized tribunals. He regularly appears as a leading arbitrator and arguing counsel for international and domestic arbitrations. He is the convener of the Indian Committee and founder member of the BRICS Legal Forum, and a director on the board of the International Legal Assistance Consortium for Sweden. Then after that, one of my esteemed colleagues on the continent from Ethiopia, Leo Tumero. She's the founder of IR Africa and also the head of arbitration at the practice Tumar Woodham Ahmun and Partners. I hope I pronounced that correctly. She is a practitioner and expert in Africa-focused international arbitration. She regularly consults in international arbitration cases concerning African private and state-owned entities. She has advised governments and international organizations on investment and policy matters, such as serving as an expert in the drafting process of the AFCFTA. And we will also touch on that from an African and a BRICS perspective and what it means for us and the exit rules. Last but not least, our South African sitting in Durban but joining us online, Professor Anil Sukul. He is one of the ambassadors for South Africa from DIRCO, the Department of International Relations, and is also special focus on BRICS and the South African envoy and Sherpa for BRICS. So he will bring, and he's also professor of the University of KwaZulu-Natal. So he'll bring some insights in terms of the South African position on BRICS, why BRICS is important for South Africa, and in turn why BRICS is important for the continent and what South Africa has been doing in respect of that. Now, before I start and hand over to the panelists, and we're going to, because of time, we might need to just swap around some of our speakers because one of our speakers needs to leave at 11:45. So, but I'm going to just quickly set the scene. The previous panel obviously spoke about broadly more from a China perspective in terms of KJAC and the importance of China-Africa trade relations. This panel, we're talking about more BRICS broadly. That's why we have participants from India, which India is also obviously one of the big economies contributing to BRICS, and then the new members of BRICS, which joined from the 1st of January 2024, based on the Johannesburg Declaration, where there is at least 5 new member states that joined. So for those who don't know, Argentina, Egypt, Ethiopia, Iran, and Saudi Arabia. Some of those members who have joined are controversial in terms of they don't even speak to each other, Iran and Saudi Arabia. But that's the nature of what BRICS is. It brings together a multitude of different cultures and people, and even people with different views. And Lindy spoke about BRICS. Thank you. Only one person, apologies. I see one of our panelists has not joined yet. Let me just make sure he joins. Apologies for the interruption. Is our South African participant. Apologies again. As I mentioned, so from a BRICS perspective, if you look at the combined GDP from the 1st of January 2024 of BRICS as a collective, it is approximately 29%, 29.3% to be exact, of the global GDP. And that, to put it into perspective, that is about $30.8 trillion US. That's a significant amount. That is almost half of the global economy. And of that, if we talk about BRICS, BRICS represents essentially the interests of the Global South. The Global South represents 85% of the world's population, or marginalized population. So that's a big voice that BRICS, as a collective of state, are representing. And if we look at the declarations, in particular the declarations during August last year in Johannesburg, it speaks about, and you can look at the theme. So the theme for the BRICS Johannesburg Declaration on the 23rd of August 2023 was BRICS and Africa. So Africa plays a significant role in the future of BRICS. And it says partnership for mutually accelerated growth, sustainable development, and inclusive multilateralism. So that's a lot of words to use. So mutually accelerated growth means all of us collectively need to go together. So from an investment perspective, from a trade perspective, but also on a sustainable basis, meaning using the resources in Africa, whether you're mining and exploiting our lithium and cobalt and so on, whether using other natural resources from the oceans, all of those things needs to be done on a sustainable basis for the collective benefit of all of us. But when people, when we talk about intra-Africa BRICS, or investment from BRICS countries into Africa, should be done on a sustainable basis where Africans also benefit. So it's not just about South Africa, but the broader African collective. And inclusive multilateralism, and that talks about the geopolitics that Seamus will also be talking about in terms of when we look at the institutions that we see today from a global perspective, whether it's in the UN Security Council and other forums, there is a clear drive, or the World Bank for that matter, where we have the New Development Bank or the BRICS Bank. In short, all of those institutions are there to serve a particular purpose, which is to serve the agenda of the Global South, to say that we need to have a bigger voice in what's happening in the global economy. But with that, obviously, there's also ultimately, when we talk about investments, when we talk about different cultures, there will be disputes, and that's what we will talk about, and that's what has been the discussions to date. Now, maybe just a few points before the panelists start is there's a few important issues that has also been discussed during this week, which is also part of the resolutions in August. One of them is the AFCFTA. So for BRICS countries, for China, Africa, Russia, investment in Africa from a trade, so investment in infrastructure is important because without infrastructure you can't trade. You have to invest in ports, roads, all the other infrastructure that makes sure that goods flow in between Africa. If we take it statistically on the African continent, there's only 15% of trade happens intra-Africa. Now, if you unlock investment from BRICS countries into the continent on equitable terms, and not terms just dictated by China and Russia and so on, so it'd be equitable, there's a lot that can be achieved. And that culminates in the BRICS legal forum resolutions, which we are going to unpack, talking about the new global order, rule of law, climate change, and very importantly, dispute settlement. So without further ado, I'm going to hand over to Dr. Dugan to set the political scene or geopolitical scene in respect of our discussion. Thank you.
Great. Good morning, everyone, and thank you, Jack Paul, for the introduction. So, as mentioned, my name is Seamus Duggan. I'm a Director of Global Risk at Control Risks, and also in a previous life, I completed a PhD in International Relations focused on Africa. So this topic is close to my heart. My job today is to provide a little bit of global context. I like to think it's the fun job on the panel. Before I talk about BRICS, I just want to take a step back and touch on some of the themes that Jack Paul was mentioning. So, in the last century, in the first half of the century, the US and its allies went about setting up a global order of institutions, rules, and norms that would set the stage internationally for the next century, let's say. There was a little bit of turbulence throughout the Cold War, but by 1989, when the Berlin Wall crumbled, and America essentially rose as a sole superpower globally. Now, what that means is that they were able to set the rules and standards that everyone would essentially have to act by. Now, historically speaking, that was a very short-lived position. As Michael kind of made a really interesting anecdote in the previous panel, he was, and I'm just going to summarize it here for those who weren't here, but he was talking about the difficulties that South Africa faced in establishing itself in the arbitration committee globally, whether it was a lack of legislation locally, a lack of expertise, and even more so, I think, headwinds from the status quo, from the international community. And they were facing these headwinds until one day China came knocking on Michael's door and gave him options to begin talking about arbitration in South Africa, in Africa. And I think, as I say, the rest is history as far as arbitration on the continent is concerned. From our perspective, though, Michael's door was one of thousands that were being knocked on in the late 90s and in the early 2000s by what was then essentially a rising superpower. So America was no longer the unipolar superpower. We could now see China rising, and alongside it, many other states. And why does that matter? If we look at Michael's case, it matters because when we have those two options, there's space for all the third parties. Countries in Africa have more agency. People had options. They could address issues in a more pragmatic sense. So it created agency outside of the US and the Americas. As we move forward into the present day, that agency has only become more acute. We talk a lot about emerging powers, about middle powers, groupings who are looking to shape global order at a regional level, but also at the global level. And this is where BRICS comes in. So if you boil it down into simple terms, BRICS is about influence. It is not a neutral or non-aligned movement. It is a group of countries who want to challenge the existing rule-based order, challenge, not overthrow, I'm just being very clear on that, and create more space for voices outside of the traditional superpowers, essentially. Now, the challenge for BRICS is that they are one of many such groupings, or one of many such actors who are trying to move into the space that has been created through competition amongst major powers globally. Some of those other actors are local regional powers, some of them are continental organizations, some of them are individual states, Kazakhstan, Indonesia, Israel. the individual members of BRICS, these are all actors on the global stage vying for influence. And what I really wanted, sort of the heart of what I wanted to say today is, in order for BRICS to succeed in what it does, it has to achieve two things. The first is there has to be substance underneath the pomp and ceremony. And I think we've heard a lot today about the substance in the legal sphere. I think more broadly, if we look at BRICS, it's an ambitious agenda. It's a financial agenda, an economic agenda, a political agenda, a legal agenda, and we are seeing substance. The new development bank, I think, has approved $32 billion in infrastructure projects. We are seeing increasingly more states settling invoices in currencies that are not the dollar. We've heard a lot from Michael, from Prof. Butler today, and from others about all the initiatives that are happening in the legal space. So I will leave it to my panelists to talk more about that substance and the success of it. The second challenge that BRICS has to confront, if it's going to be relevant, is legitimacy. So once we've built all the rules, once we've got the foundations of an order in place, why should people use them? What is it, why should we use what BRICS creates as opposed to what already exists or what other bodies create? And I'm going to be a little bit unfair here and make a comparison that's probably not entirely fair on BRICS, but I think it's an interesting thought experiment. So compare BRICS to OPEC. Now, OPEC is a grouping that also started as 5 states, I think, in 1960. What OPEC does influences every single person in this room. They have a very specific, targeted influence on the world. They have very clear standards for membership. You have to be a net oil exporter. They have a very clear agenda to, I suppose, maximize profits amongst their states. And they have a very clear means of exercising this influence to increase or decrease the supply of oil globally. Now, I say it's an unfair comparison, but think about what OPEC can do versus what an organization like BRICS can do. And yes, BRICS is more complicated, it's more complex, it's looking to operate in different spheres. But again, if BRICS is to be relevant, substance and legitimacy are going to be the challenges that they have to confront. Thank you very much.
Thank you, Seamus. That was, I think, contextualizing just our discussion from a geopolitical perspective is, there's a lot of complexity involved because of the different players we have. And everyone also has different interests at heart, whether it's in the same grouping also, so there's different economic interests at play. So it's important to balance that. And that also goes to the question about, if you look at the BRICS grouping, there's no treaty that regulates how they operate. It is a loose formation of states that says we have a common objective, and this is the common objective in terms of we are the voice again for the global south. And there is institutions developing. One of them is obviously also the BRICS Dispute Settlement Center that is coming to fruition. Now, next is our speaker from New Delhi, Mr. Kumar. I'm not sure, Mr. Kumar, are you available?
Yes, thanks, Jackwell.
Mr.
You
Kumar.
can hear me?
Yes, we can hear you. Mr. Kumar, if you want to start in giving us some context to the December 2003 resolution, you've been one of the authors and drafters in Johannesburg, and what it ultimately underpins also from a dispute settlement perspective. Thank you.
Thank you, Jackwell. I'm delighted to be participating in this Johannesburg Arbitration Week, and I commend the organizers for having organized a wonderful event. I'm sorry I could not travel to Johannesburg to participate physically due to certain commitments. See, I am involved with the BRICS Legal Firm from 2014. And in 2015, when we met for the second time after meeting in Brasilia, in Shanghai, is the central topic became the establishment of some sort of BRICS dispute resolution institutions. And SHIEC was the first one which presented itself as one of the centers in which such disputes could be carried out. Now, the second one was in New Delhi, and from there on, we thought that the trade flows within the BRICS may not sustain an institution network because they are between Brazil and India. It is now rising, but they were not so much to have an institution independently devoted to it. So even otherwise, the BRICS overall conceptualization is to provide a voice for Global South. So that's why in 2016, when we established, mooted the New Delhi Center, the idea was to also encompass the emerging economies, meaning thereby the Global South. So after that, we had some plan of action, we had some concept notes, and the discussions continued to evolve into practical formulations. And then in December 2023 at Johannesburg, we came to an agreement that let us not reinvent the wheel, and for the basic set of rules, which of course had to be adopted to the conceptualization of the overall network, we adopt the EFSA rules. And I'm glad to inform that after that, in February, we have circulated the modified rules for discussions in February, March. And in May, we are hoping to have, the group meetings. And later on, towards end of March, even what will be the configuration of the Board of Governors of the entire network, and how the work sharing will happen, how the financial arrangements will be in place. So some ideas about that have also been circulated. So the work is going on in steady direction, so that when we meet in September in Moscow, we have something which is there, which we can take a call on and adopt as a formulation. Now, the main issue is, as far as the world of dispute resolution is concerned, that it is not merely to have the institutions which are sensitive to the development needs and also the distinct legal cultures Global South countries and others represent, and the various stages of legal capacities they possess. So the formulation of the network and bringing network to activity is very deeply correlated with developing capacities. And once the set of rules are there and all, we have to start a regular process along with the stakeholders to develop capacities. And the main issue is that apart from those who are expert in arbitration, you should have experts sitting in various arbitration panels who also understand the ground realities, the legal cultures, and the economic situation while deciding disputes. And that is more important in the sphere of investment disputes. So that is something which is still in works. The rules regarding commercial arbitration are more or less in place, and the modified version has been circulated, but investment disputes is a completely different ballgame. And that is where much more work is to be done. In Johannesburg, we have just, in the declaration, thought about establishing a specialized wing of BRICS dispute resolution network. But ultimately, we have to go beyond that, because, putting it together is one thing, but making it operational, making others to sign up is a very long drawn process. So hopefully we'll have more clarity of views that what should be the outline of any BRICS institution in terms of investment treaty, BIT disputes and all. So the next most important aspect is that we have to now expand to the new members of the BRICS. And we are very glad that we have a panel from the new countries which are joining the BRICS initiative. And I congratulate the organizers for that. Because ultimately, this is the first year they are joining in. There is lack of clarity on the other stakeholders that, what is their government's view, how they have to move with it. But we will like to organize some meetings prior to September Forum so that we can have more clear idea and we can also discuss and, take all the new entrants into confidence on what we have done so far so that they can join in and contribute constructively in the creation of and launch of this network. So this is where we stand. It is progressing in a very sure-footed manner, and we are very hopeful because generally when you meet, there is huge discontent in the way commercial arbitration is run. It is very costly, very expensive. It is almost, unaffordable from the parties coming from developing countries, and they don't have a very high level of confidence. So the challenge is how the BRICS institution network is able to establish itself as a viable alternative with lower costs and while using local capacities. So that is the task cut out with us. It is not a short-term agenda, it is a long-term agenda, but we hope something more concrete to emerge in September in Moscow when we meet.
Thank you, Mr. Kumar. I think that was enlightening, unpacking in particular what has happened during the discussion and the ultimate resolutions in December 2023, and also what is actually happening on the ground on a day-to-day basis. So it's not as if things are standing still. There's work at the background to make sure that this happens. And I think one of the important points is also the complexity around, yes, commercial dispute settlement is probably much easier because we're establishing institutions, but it's the investment dispute settlement. And will there be a competitor to exit? Because is there a need to have a competitor to exit? Because you rather probably try and reform the institution as opposed to having a competitor. So those are the debates that needs to be still had and finalized. And then I turn to Leo, Ms. Leo Tumero, as the new member on the block from Ethiopia, representing BRICS Plus, adding that to $3 trillion to the grouping. Leo, from Ethiopian perspective, I think if you can unpack what does it mean for Ethiopia, being one of the only East African countries that are now part of BRICS, and how that will contribute to Ethiopia, but also broadly the East African region. Thank you. Wherever you're comfortable.
Thank you very much. It is quite a pleasure to be back in South Africa after so many years. I just realized as I was renewing my passport that I hadn't been here for 5 years. So it's great to be back, and it's great to see familiar faces and also meet some new players in this arbitration game. Let me start off by just building on what the previous speaker was talking about and the challenges that we've had with regards to ISDS. So firstly, the African continent is one of the continents that's most sought after in terms of a trading partner. And let me explain why and how. So the way in which the world has been doing trade lately, and that's post-decolonization 1960s, is by signing bilateral investment treaties. And these bilateral investment treaties have the goal of having let's say, an investment exporting country with an investment importing country. And the goal is to kind of provide a protection and provide some sort of confidence for those that have the money to come and spend their money in those that need the investment or have the resources. Now, in the world, there are about 3,000 bilateral investment treaties signed. Out of the 3,000 bilateral investment treaties signed, 1/3 are with an African country. And I think this is quite indicative of the importance of the African continent with regards to trade. if 1,000 BITs, 1,000 plus BITs have been signed with African countries. And I'll just give you a quick information on which ones are. So out of the 1,000, the ones that are not in force and have been signed, the top 3 countries are Germany, Switzerland, and China. Now, the top 3 bilateral investment treaties signed with, that are actually currently in force are with Germany, Switzerland, and Italy. And I think this establishes something, which is the way the West has done business with the African continent is through bilateral investment treaties and through the protection and the regime that these bilateral investment treaties have brought about. So what has actually been the impact of these bilateral investment treaties and this regime on dispute settlement, particularly the investor-state dispute settlement? So a few years ago, we did about a research on the known ISDS cases concerning African countries, and we found about 211 known ISDS cases. And out of these 211 known ISDS cases from 1970 till about 2017, we find some very interesting data points. The first is, where do these disputes go? These disputes go to the ICSID. The majority of the disputes go to the International Center for the Settlement of Investment Disputes. The second center was, not surprisingly, PCA, and the third centers are the ICC and the Stockholm Chamber of Commerce, which are partly almost tied. So that's one. So the disputes are happening outside of the African continent. The second part that we've seen is, how much are these disputes for? What's the median amount? So the largest dispute amount claimed in a dispute is $6.5 billion. And I think this is a case that most of you are familiar with, which is the PNID case concerning Nigeria, which was successfully set aside. Now, the median amount, however, having seen that, is about $121 million is the median amount of claimed in an ISDS case concerning an African party. What we've seen also is that all but one African state have had an ISDS case brought before them. The countries with the largest number of ISDS cases, not surprisingly, are also the countries with the highest number of BITs signed, the number one of which is Egypt. So this is kind of data point and background in terms of how the regime of doing investment and resolving disputes through that regime has been going. So the past few years, there's obviously been a shift in terms of moving from that to now come up with a different format. And one of them, and the major one of which, is the African Continental Free Trade Agreement. The purpose of this agreement is, as stated, and there will be a panel later, so let me use this as quick promotion for the breakout session panel later so you can hear more about this. The purpose of the CFTA really is to, as Jacqueline also mentioned, is to increase the intra-Africa trade from 15% to 25% or so. One of the biggest challenges that we have on the continent is that we are the continent that does the least business with itself. Imagine, you do not sell to your neighbor, you sell to those that are so far away that you actually have to use planes and boats and whatnot to get there. So I think that's a very fascinating point to me. Now, as we build this infrastructure of the AFCFTA, the biggest problem and the biggest issue that we're grappling with, not surprisingly, is under which terms what kind of regime do we now put in place to be able to trade amongst ourselves? Do we copy the same regime that we've had previously? We see the result, and we're not very happy with the result. Do we come up with a different regime? And if we do come up with a different regime, is that regime going to be less favorable to Africans as we trade amongst ourselves? And we have given those outside of Africa a better regime and a better protection mechanism that allows us to even still have a preferential treatment to those that are outside of the African continent. And that's really one of the major points we're grappling with as we kind of design this dispute resolution mechanism. But it is a clear indication that we are looking to move away from these systems. And as we do, it is obviously a no-brainer for Ethiopia and other countries that are known as emerging and developing countries, emerging economies, developing countries, who want to join other blocs, other systems that somehow present a South-to-South kind of relationship. I mean, BRICS is a clear move that is different from a I will help you structure that we've kind of lived in to let's actually help each other. We both have value to each other, which is a completely different mechanism. Just a quick background about my country and the new kid on the block, one of the new kids on the block in BRICS. Ethiopia is the second largest populous country, most populous country in Africa. We have about 126 million population. It is a country that is expected to be a middle-income country in 2025. It has had a growth of about 15 to 7% throughout the past 30 years, which has unfortunately been a bit troubled by a recent civil war, which has had also an interesting impact on why I believe Ethiopia has chosen to join BRICS. So let me just give you a quick view of what we export and what our trading is in Ethiopia. And in Ethiopia, one of the main trades is coffee. I'm sure many of you know that Ethiopia is the nation that has gifted coffee to the world. But it really is an agriculture-focused country. So the majority of our exports are really agriculture-based. So it's coffee, it's pulses, it's seeds, but we also have cattle and meat that we also export. And so the question is, who are we exporting to? When you think about who we're exporting to, our largest exports go to the UAE, the US, and I'll come back to that shortly, and China. So this is where our investments are going. Not surprising, countries that are part of BRICS, right? And the other question is, who is investing in Ethiopia? As we look at who is investing in Ethiopia, China, Turkey, Saudi Arabia, the UAE. Also, not quite a surprise why Ethiopia will join BRICS. Now, one of the points I believe that has also pushed Ethiopia to join BRICS, as I mentioned earlier, the US is one of the biggest trading partners to Ethiopia. And one of the main exports that Ethiopia had to the US was particularly textile and manufacturing related goods. And why was that the case? That was the case because of AGOA. AGOA is the African Growth Opportunity Act, which was the mechanism through which the US was encouraging and providing preferential trading mechanism for African countries, particularly sub-Saharan African countries, to export goods in the US and to provide them the US as a market. And through that, about 11% of Ethiopia's exports were that. So because of that, we had many companies move into Ethiopia, particularly for textile manufacturing, and a lot of the imports in leather and hides was also going to the US. But what happened? There was a war in Ethiopia in 2021 where there were gross violations of human rights. And one of the ways in which the US showed its disapproval of that was to suspend Ethiopia from AGOA, which then created a sharp decline, as you can imagine, in exports from Ethiopia to the US, but also very big frustration economically from all of these manufacturing companies that had specifically moved to Ethiopia to be able to engage in that trade. And I think it's these kinds of attitudes that have made it so that Ethiopia decides to join the BRICS particularly, or even look at alternative partners who would not use trade, who would not use livelihoods as means of sending a political message. So I'll end on that note, and perhaps we'll have a discussion on this point later. Thank you.
Thank you, Leo. That was insightful, what's happening in Ethiopia. And I think maybe something you mentioned to me is there's a lot of reform also happening from a manufacturing perspective into Ethiopia. So it's a great country that will contribute significantly, I think, to the BRICS bloc, but also broadly to the African continent in terms of opportunities and a gateway into East Africa. Now, this is either a blessing or not, is that our South African speaker, His Excellency the Ambassador, unfortunately cannot join us anymore because he had another engagement after quarter to 11. I would take it as a blessing because we are running out of time. So maybe that allows us just to have a few questions to the panel, and then we can close the session because I think everyone deserves a cup of coffee from Ethiopia, or some tea if you want. So I think the first question is just again to Seamus, in terms of geopolitics and based on the discussions that we've had now on the BRICS, the G7 or the West, if we look at particular risk, and I'm going to mention a live example in respect of, so prior to the BRICS summit that happened in South Africa last year, we as a firm were approached by a lot of people who were very jittery, so because Russia has sanctions, China has some sanctions, and they are concerned. So if we attend these meetings, in particular the BRICS Business Council, and we attend these meetings, is there a risk for us as investors coming to this type of summit or conference, sitting next to a Russian or sitting next to, say, a Chinese or other nationals that are potentially sanctioned by the US for whatever reason? Is there exposure to them? Maybe from a geopolitical perspective, and this is also touching on the US dollar and all of those other things. What is your perspective about all of these things, and what is the way forward for investors and traders, let's say?
Yeah, no, it's a very interesting question, Jack. And actually, so, Control Risk, we have about 40 offices globally. One of those was in Moscow. And we actually had to close it and relocate our staff from Moscow to London and elsewhere, Dubai, for the reasons that you're touching on. And obviously, we've heard many cases of that happening to other companies who, because of the sanctions risk, had to sort of take that action. It's also interesting that you mentioned sort of attending summits, sitting next to people. So my American colleagues, for example, because of the sanctions, have to be very careful about who they meet with and what they say in meetings. Before what happened in Ukraine, Iran, for example, American consultants were not allowed to talk about Iran or to give advice to companies operating in Iran, for example. So we've seen very sort of real impact there. Geopolitically, the other sort of issue we're facing is that we talked about the shift, about sort of having sort of two poles and all the space that's created in between them. There's a lot of very real change happening that is impacting companies, and maybe I'll just focus on three of them. So the first is in the technology space. There's rivalry and competition over technology in particular, and we're seeing more and more protections to prevent technology flows across borders, for example, that is disrupting businesses. The second is in security alliances. NATO has expanded, and as the US, China, Russia are focusing on Europe, for example, it is leaving behind vacuums in some of the other parts of the world, in Africa, for example. And the third, and probably the most relevant for many, is critical minerals. Some of the disruptions we've seen in geopolitics has created competition for critical minerals that has a very real impact, particularly on businesses operating in Africa. So there's a lot of things to say to that question, but those are the key points for now.
Oh, for sure. It's very fluid. That's the thing. Then a question to Mr. Kumar in India, maybe just taking it back or circling back to investment dispute settlement, and maybe you can give us your views also from an Indian perspective. What is your take on how do we take it forward? So there has been the resolution in terms of there should be a forum that deals with dispute settlement, but what is the actual way forward? Is it reform? Is it establishing a separate institution? And how will that look, Mr. Kumar? Mr. Kumar, I'm not sure if you heard me. Maybe I can go to Leo first if Mr. Kumar is not available. I think the same question, and you probably have touched on it because it's an important question from an investment perspective. If someone from China or Russia invests in Ethiopia or in Rwanda, now we know of the South Africa and China as a BIT, South Africa and Russia as a BIT, but not all of these countries have BITs. In particular, Brazil doesn't like BITs. So what is your view in respect of, so should there be more reform in terms of maybe a multilateral investment treaty or BITs, or is it not necessary? What is Ethiopia's position in respect of that? Then we spoke earlier about this interesting BIT between Ethiopia and UAE, who's also a member of the new bloc.
I think, so I think the biggest jobs, like the toughest job that the drafters at BRICS actually have is really identifying what mechanism would work. Because you really are caught in a situation where you have direct access to investor-state dispute settlement mechanisms in all the BITs that you've signed with, but then you also want to encourage here. Now, we have to look at it in two different ways. The biggest investors, you know, the big state-owned entities, the big, you know, the multinational companies, they don't need these trading mechanisms to cross borders. They're already crossing borders. Multiple Chinese companies are crossing borders and coming to Africa to invest. And it's not because they have an ongoing bilateral investment treaty or an enforced bilateral investment treaty. Multiple, you know, the Dangotes of the continent, the MTNs of the continent are crossing borders. These major trading agreements, they're not just for government. They are for medium and small entities. And the protection that needs to be offered is with the understanding that it's for the medium and small entities. And so when you take that into consideration, you have to think of a mechanism that will be accessible to these medium and small entities, because the other entities have direct access to their governments. They have no problems getting their governments to speak to the host country or the home country, et cetera, to be able to resolve that dispute. So they would have to come back. Whatever system is, I hope they have kind of a system that does play into that, you know, takes that into consideration. But, and one final point I'd say is I hope the drafters move away from a reactionary drafting style, from which I think a bit of the CFTA investment protocol is, a reactionary investment style, you know, kind of drafting style from the current status quo, and really consider who is going to be, who's going to be.
Yeah, it should be clearly thought about how we move forward and what works, taking into account balancing so many interests in this block. And I think, Mr. Kumar, I'm not sure if you heard my question. Maybe you want to comment on that, on the investment dispute settlement mechanism from a BRICS perspective, just unpacking it a bit more.
Sure, sorry, because of the sessions started very late. I had a meeting, so I jumped in it and I've come
Apologies.
back. My view is a little bit on the basic conceptualization itself. Most of the companies, they go to emerging economies and outside their territories for the purpose of profit. And when you go to the jurisdictions where you have, you know that there are risks involved, but you go there still because those risks present a higher level of profit. So when you are investing, say in Europe or any other established, economically well established, with the very well rule of law, independent judiciary and all, so your interests are protected by the system itself. You want to have these protections when you go to the countries which don't have such firm systems. So except when you are going to implement a very big infrastructure project with very low rate of returns, and it is almost a kind of a development assistance project, the question of a separate investment dispute mechanism predicated on a treaty should come in. But once the companies are going in jurisdictions for extra profit, in your own jurisdiction, your rate of return on investment is 5%, you want to go somewhere, and you have already calculated that, to work here, we should have a 20% rate of return because of lack of competition, your scale of operations and all. Why additional layer of protection has to be there?
Yeah.
Because if you go to the basic economic logic, profit is in direct proportion to risk. So you want to have a higher profit and you want to have lower risk. So this is like having your toast buttered from both sides. So the way, and it is my personal view, the way I look at it is that yes, there is a need for investment treaty or some other mechanism to resolve dispute, but it should be strictly where the rate of return is minimal and it is more in the nature of a development assistance project, not a private enterprise venturing into a new country to have higher profit. The basic economic logic.
Yeah. No, thank you for that insight, Mr. Kumar. And we've also, I think because of time, we've gotten to the end of the session. I think it was an insightful discussion from the beginning till the end. Just contextualizing BRICS, where we are, where we're going, the complexities around BRICS, and the geopolitics involved. So thank you to the panel. It was a great session. Thank you. You want to take a...
Distinguished guests, ladies and gentlemen, good afternoon. It's my great pleasure and honor to speak at Johannesburg Arbitration Week. On behalf of the International Commercial Dispute Prevention and Settlement Organization, ICD-PASO, I would like to extend my congratulations to the Arbitration Foundation of Southern Africa, AFSA, for the successful organizing of JOO 2024. In the past 3 days, distinguished speakers and experts of different fields have shared their views on the latest development of dispute resolution in Africa and across the world, and conducted specific discussions covering energy, mining, artificial intelligence, ESG, integrity, and other topics. It has provided an invaluable platform for arbitration practitioners to engage in deep discussions and unpack issues and challenges facing the fast-changing world of international commercial arbitration. ICD-PASO is privileged to be associated with this important and dynamic event, the JOO 2024, and its organizer, AFSA. As Africa's top arbitration center, AFSA has made extraordinary achievements in promoting arbitration across the African continent. AFSA is one of the founding members of ICD-PASO and has maintained close ties with ICD-PASO through active engagement and collaboration in the past years. Established in 2020 as a non-governmental, non-profit international organization, ICD-PASO is committed to providing accessible, independent, efficient, and trusted dispute prevention and resolution services, including mediation and arbitration, to parties from all over the world.
As part of its commitment to promote and facilitate the efficient resolution of commercial disputes, ICD PASO introduced its arbitration rules and mediation rules in 2022. These rules address the evolving needs of business communities and provide the parties, mediators, and arbitrators with flexibility, efficiency, and transparency throughout the proceedings. Recent times have seen an increased focus on drivers of change and new frontiers. Technology continues to be widely integrated in international arbitration. ESG factors are profoundly interwoven with commercial disputes. Concerns on diversity of arbitral tribunals and information security are rising, and arbitration is increasingly recognized as a preferred method for resolving complex intellectual property disputes. Commercial arbitration's inherent flexibility and party autonomy allow it to adapt and innovate in response to the needs of users. We, the Arbitration Committee, shall make joint efforts to expand our capabilities, to embrace and leverage technologies, and to enhance diversity and inclusiveness, ensuring that arbitration remains the robust method for resolving cross-border disputes in the face of evolving global dynamics. Ladies and gentlemen, let me take this opportunity to congratulate EFSA once again for successfully organizing the JOR 2024, and thank all the distinguished speakers and all the participants for sharing your valuable insights and expertise. We at ICD PASO are looking forward to future collaborations with EFSA and all of you to promote international arbitration and ADR as peaceful means of dispute resolution, which ensure access to justice, uphold the rule of law, and contribute to sustainable global economy. Thank you.
forget about the voting of the mood. The deadline is 2:30, and we will appreciate your feedback. Now, we will delve into the overcoming obstacles of arbitration in our session. I'm Svetlana Vasilyeva, the Secretary General of AFSI International, and it is my incredible privilege and honor to moderate this session. In today's session, our exceptional panel will share their experience in addressing some of the most pressing challenges in the field of arbitration. First of our speaker is Dr. Niels Scheersing. Dr. Scheersing is independent arbitrator at arbitration chambers and an esteemed member of AFSI International Panel of Arbitrators. He is also FCARB and CARB Fellow with expertise in common law and civil law systems, which will bring us a wealth of global experience. He is dual qualified and admitted to practice law in Denmark and English and Wales. Dr. Scheersing's expertise spans numerous jurisdictions. In his presentation, he will take us through the intricacies of case management conference and drafting of the procedural order number 1, a topic crucial for the effective arbitration proceeding, and exploring the purpose of procedural intricacies of case management conference, debating the merits of issuing draft procedural order ahead of case management conference versus sending the comprehensive agenda. Dr. Scheersing's talks promises to illuminate the best practices and offer strategic guidance for navigating arbitration proceedings, underscoring the collaborative spirit essential for the successful dispute resolution. Following Dr. Scheersing, Bruce Collins KC is our next esteemed speaker. Bruce is distinguished legal mind and respected commercial law and arbitration authority, as well as esteemed AFSI International Court member. With over 40 years of experience, Bruce will share his understanding of the challenges in the appointment of arbitrators, especially concerning the questions of impartiality, and will provide invaluable perspective of our discussion. His presentation will talk us through the nuances and complexities of transparency, impartiality, and fairness in arbitration proceeding. Last but not least is Jean-Remy Demestre, the CEO of the Just Mundi, who will explore the groundbreaking role of artificial intelligence in powering arbitration and advancing global justice. Jean-Remy stands at the forefront of one of the most innovative intersections of our field today, the integration of artificial intelligence with international arbitration. In his presentation, Jean-Remy will unveil the exceptional work being done at Just Mundi in creating the world's first comprehensive international arbitration database. This pioneering effort not only easy access to the global justice, but also exemplifies the transformative power of technology in our domain. Now I will invite our first speaker, Dr. Niels Scheersing. Niels, the floor is yours.
Thank you very much, Svetlana, and thank you all for coming here at the final day of this exceptional conference to listen to what I and the other panel members we have to say. My topic, as those of you heavily involved in arbitration will know, is a very practical one, and the case management conference is a very important for the efficient conduct of the arbitration. It's a topic that I could speak about for probably 3 or 4 hours. I have 10 minutes, so you will appreciate that I will not cover it extensively. I will try to, I've considered how to deal with this, and I'll latch on to what Patrick Lane said the other day. I'm trying to give you an introduction to the topic for those of you not so familiar with international arbitration, that you can probably build on that later. In my opinion, arbitration can sensibly be divided into 4 stages. Stage 1 is the preparatory stage. Stage 2 is the hearing stage. Stage 3 is the post-hearing stage, and then you can say stage 4 is the awards stage. And the case management conference and the procedural order number 1 belong to the first stage of the arbitration. It's a fixture and a stable of, I would say, every arbitration, at least every international arbitration. And it's customary that the tribunal, once constituted, and when they first reach out to the parties by way of an email, that they convene a case management conference. Some institutional rules call them preliminary meetings, some call them procedural hearings. They could also be called preparatory meetings. And the purpose of the CMC, the Case Management Conference, is succinctly set out in AFSA International Arbitration, AFSA International Rules, Article 15.3, where it says that the tribunal shall hold a case management conference to establish any additional procedural rules and a procedural timetable. You have more or less the same in the ICC rules. So those are the two the purpose are set out. Those are the 2 main purposes of the CMC. However, there is an additional purpose from the tribunal's perspective. It is the case management conference is an opportunity to infuse some collaborative spirit into the arbitration and see if you can get the parties to work together on procedural directions. And it's also a chance for you to establish the overall authority of the tribunal. In my opinion, it's hard to overstate the importance of the case management conference. It helps to set out the tone for the whole arbitration, and it will often reveal the case management skills of the arbitral tribunal, not least the chairman. And what you need as an arbitrator at the case management conference is a certain level of flexibility. You need to be able to listen to and assimilate the views expressed by counsel, and you need to be quick on your feet and try to come up with pragmatic solutions if the parties disagree. And if the parties ultimately cannot agree, then you need to decide on the disagreements between the parties at the case management conference. So, in the preparation for the case management conference, here I have a quote from my standard email to the parties, where I invite the claimant and the respondent to work together to see if they can come up with some joint proposals for procedural directions. And very often they can, maybe not everything, but they can come up with some, they can agree on some issues of procedure. In preparation for the case management conference, you can send out a draft procedural order number 1, or you can send out an agenda. And I know different arbitrators hold different views. I hold the latter view. I prefer not to include a draft PO1, but to send out a comprehensive agenda for the parties to base their discussions on. Here I have, it's almost impossible to read, I'm sorry. Here I have some of the items on a provisional agenda that I normally send out to the parties in the first email. The standard, and what you need to do is you need to adapt your standard agenda. You need to adapt it to the jurisdiction that the arbitration takes place in, i.e. the seat of the arbitration. Here you can see item 1 says any issues related to powers of attorney and party representation. Is because it's a case seated in the Middle East where issues of powers of attorney are very prevalent in arbitration, and they are important first steps. And then you need to also adapt them to what's been happening in the arbitration so far. At the case management conference, you will typically be in possession of a request for arbitration by the claimant and an answer by the respondent. So you will know, have some high-level indications of what the issues in contention are. And you can see here in item number, let me see, which one is it? It's item number 5, where it says any potential preliminary issues or bifurcation. In this case, there was a jurisdictional objection to some of the requests for relief. And this is when do we then bifurcate the proceedings to deal with that first, or do we deal with everything in one go? So that is how you adapt your agenda to the conduct of the arbitration until the case management conference. At the case management conference, you go through the agenda item by item, and you note any disagreement and agreement between the parties, and then where there is disagreement, you let the parties make submissions. You then probe to see if a common ground can be established, and if not, then the tribunal will have to make a decision. The most professional counsel, they will often, in advance of the case management conference, respond to the tribunal, and they respond either by email, or they may respond, I've had that a number of times, they respond by sending back a table where they have the provisional items on the provisional agenda included, and then note item for item agreement or disagreement. And that is extraordinarily helpful for the tribunal. It helps focus the discussions at the case management conference. Then, based on the case management conference, the tribunal will prepare either a procedural order number 1 or terms of reference or something similar. And I have, there are some people prefer the procedural order number 1. I have actually come to prefer to deal with it by way of either terms of reference or, as I even call it now, a procedural agreement on the conduct of arbitration. And that is because a procedural order reflects the decisions by the tribunal, whereas a terms of reference or procedural agreement will also involve the parties. And you have the parties written commitment, they will sign the terms of reference, they will sign the procedural agreement as reflecting their, that they accept the terms. I probably have very little time left, so I will only deal with one issue on the provisional agenda, and that is item number 6 on the agenda, where it says adoption of the pleading style or the memorial style, or a hybrid another approach concerning the preparatory phase of the proceedings. Some of you will undoubtedly be familiar with the distinction between the pleading style and the memorial style. For those of you who are not, I will briefly go through them. The memorial style, as I said here, the key word is you front load the proceedings. What you can divide it into 3 or 4 phases, and they are all, the first phase is consecutive. You send the statement of claim, the factual exhibits, the witness statement, and the expert reports. And then you have a second phase, which is document production. You have a third phase where you go back to the consecutive exchange of statement of reply, statement of rejoinder. And then you may have a fourth phase where we have a joint expert report. The key here is that the written statements by the parties, they include everything. They include documentary evidence, they include witness statements, and they include expert evidence, and they may even include legal authorities relied upon. You can contrast that with the pleading style, where you can say that is based on focusing the proceedings. Here, what the parties, they do consecutively normally I prefer to have 4 exchanges of 2 each, but the parties only submit their written statements and the documentary evidence. They do not submit witness statements. They do not tender expert evidence at the pleadings, the first phase. Then you have the second phase, which is basically, once again, the document production, where you simultaneously exchanged requests and the tribunal rules on that. And then you have the third phase where you remain in simultaneous exchange, where you first have the witness statements and then you typically have the expert evidence tendered afterwards. Different arbitrators prefer, and counsel prefer, different approaches. Some say overall that they prefer the memorial style, and some say they prefer the pleading style. When you encounter common law trained counsel, they will very often prefer the pleading style, because that's what they know also that's common to them from the civil procedure. In my opinion, it's horses for courses. If you have an arbitration that is heavy on legal matters, not so fact heavy, it's about contract interpretation and so on, then the memorial style, I think, is very well suited for a case like that. I recently had a case in the pharmaceutical industry. It was about whether the pharmaceutical company was under an obligation to order a minimum of some product from its counterparty, and that was hinged on an interpretation of the contract between the parties, and that we adopted the memorial style. Where you have more factually complex cases, typical construction engineering, some mining cases are very fact heavy. You rely on witness evidence and not least expert evidence. In those cases, I think and I think most experienced arbitrators will agree for that. The pleading style is the better suited approach to that kind of arbitration. How much time do I have left? My final words will be I will go to the post-hearing phase, and just to offer one food for thought. The post-hearing phase is after the hearing, and where parties will exchange post-hearing submissions instead of making oral closing arguments at the hearing. What I have come to suggest more and more to parties is that apart from the post-hearing submissions, you also exchange what I call summary submissions. And a summary submission is basically a summary of the party's contentions in the case as that party wishes its contentions to be reflected verbatim in the award. By adopting a summary submission style proceeding, you will avoid the tribunal having to paraphrase the parties. The parties themselves are in charge of how they would like their legal and factual submissions to be reflected in the award. And I say parties are often agreeable to that. They prefer to have, so to say, the final say in how the award will reflect their submissions. That's an idea I'm happy to pass on to you. I think I'm out of time. This is, as you will hopefully agree, this is a time that is extraordinarily well suited for the professional training that Patrick talked about on Tuesday, and I hope somebody will talk about that at the various workshops later on. Thank you so much.
Thank you very much, Niels. Now, our second speaker, Bruce Collins, KC, will walk us through the challenges to the appointment of the arbitrator. Bruce, in your view, how does the International Bar Association guidelines emphasis on transparency and disclosure contribute or challenge the traditional understanding of arbitrator impartiality?
I'll answer that first, if you like. I consider that the IBA guidelines are a wonderful gift to us all, and they are so appropriate to resolving the issues with which they intend to deal that they have swept away the necessity to regard any of the steps which are comprised within them as controversial. That means that the test for whether or not an arbitrator should be recused as a consequence of an appearance of impartiality has been made the subject of a detailed analysis by a very talented group of people who comprised, in almost even measure, common lawyers and civil lawyers. And in the manner in which that particular exercise was conducted, we have seen a vital fusion of the principles of law which lie at the heart of international arbitration. I don't want to beat around the bush, but in my view, there is no longer any meaningful purpose in trying to find any aspects which are controversial in the IBA guidelines. For the purposes of the discussion that I want to engage in a few moments, I'm going to look at the problem in two ways. First of all, what I might call the relationship issues that are dealt with very well in the green, orange and red lists, noting that those lists are not conclusive and are not ultimately prescriptive. They will give rise to further categories which will need to be assessed on a case-by-case basis. But the IBA rules consist of much more than rote lists. The point about the IBA rules is that they now stand as the gold standard for the test for ostensible, apparent impartiality. And I want to lay down for you and then endeavour to show the breadth of their application what the test is. And we'll talk about the Halliburton decision on an interim basis as and when we arrive at an important stopping off point. But what needs to be shown is that a reasonable third person, having knowledge of the relevant facts, an important category of illusory reference, which has now been dealt with in considerable detail in Halliburton, having knowledge of the relevant facts, giving rise to justifiable doubts. Giving rise to justifiable doubts. Now, justifiable doubts indicates that the standard to be applied in determining the existence of such things is objective. It's interesting to note that in the 6 years I spent as a member of the ICC court in Paris, the members managed to get themselves in all sorts of confused knots because they saw the words in one of the ICC rules in the eyes of the parties, which is a concept that related exclusively to disclosure and not to whether or not there was a justifiable doubt as to impartiality. And a lot of ink has been spilled in order to try to convince the reader that the reference to the eyes of the parties meant that the standard by which impartiality should be judged was subjective. And it was only until people like myself and a wonderful chap called Michael Young QC began to speak at length in the monthly meetings of the court that we sorted it out. Now, there is a similar expression in the AFSA rules, and I don't want it to be thought that I'm criticising the AFSA rules for having those words in them. Where the AFSA rules deals with the issue, it is clearly an issue relating only to disclosure and not to the proof of the question whether there are grounds for doubting the impartiality of the arbitrator. The other reason why you needn't be fussed about the presence in the AFSA rules in the disclosure section of the expression in the eyes of the parties is that the ICC rules do not contain the expression justifiable doubts as to the arbitrator's impartiality. Those words do appear in the AFSA rules, and I commend the AFSA rules to you. So to this point, I've said two things which are intended to prevent you wasting your time looking for gremlins in the structure that we're now working under. Firstly, the IBA rules are a gift. Secondly, they should be applied. Thirdly, their spirit and intendment has been wonderfully grasped by the draftsman of the IBA rules. So again, trying to maintain my focus, could I give you 5 points to support what I've just said? Firstly, one of the best cases on this subject was a decision of the House of Lords in Porter and McGill, and that referred to a test which concerned the fair-minded and well-informed person concluding that there was a real possibility of bias. In other words, how things appear objectively. The UNCITRAL article, which is a wonderful piece of collaborative international work, speaks of circumstances existing that give rise to justifiable doubts. Now, doubts are just that. You need to prove the existence of a doubt. You don't have to prove the existence of facts which give rise to a doubt. A justifiable doubt is just that. It's a thing that can be proved by appropriate evidence. AFSA Article 13 uses the same expression as does the UNCITRAL rule, circumstances giving rise to justifiable doubts as to the arbitrator's impartiality. The LCIA rules are the same as UNCITRAL, and the UK Arbitration Act talks about circumstances existing that give rise to justifiable doubts. So that ought to justify a conclusion by all of us that that part of the law is settled. And it's important to proceed from that to look at cases like Halliburton and the British Tobacco case in the High Court in Australia, which seeks to flesh out this idea of the reasonable man. Now, I shan't have time to deal with that today, but if you read Halliburton with a pencil in your hand, you can just list off each of the matters which are used to infuse the notion of the reasonable man with a cognizable personality. In other words, it vivifies the reasonable man, and Halliburton will give you an uncontroversial statement as to the knowledge that this person is presumed to have when he is made corporeal. Now, I want to just talk about some matters in opening, because there have been considerable changes in the way in which these issues have been decided in the past. During my time on the ICC court, there were occasions when the court was averaging 2 challenges every month, and at the high point of a rash of challenges, 58 challenges were dealt with in a year. In my view, most of those challenges were nonsense, and because of that view that I expressed forcefully, it became my job to write reports for the whole of the court each month, and I'm still reeling, in a sense, from some of the nonsense that was proposed. Unfortunately, what has been generated as a result of these challenges, which have mounted proportionally in other parts of the world, is the growth of what has been aptly described as due process paranoia. Now, due process paranoia has been one of the consequences of the looming prospects of a challenge, and the other consequence is an elevation of the importance of the arbitrator's disclosure. Now, as to arbitrator's disclosure, I want to commend again, as I did a few moments ago, the decision in Halliburton. Now, whatever you think about the result in Halliburton, and I'll give you a formula to make that assessment shortly, you cannot complain about the way in which Lord Hodge set out all of the general principles about disclosure. The arbitrator's prior disclosure is, in the way I've suggested, that the IBA rules deal with the question of impartiality, has resolved once and for all in a satisfactory manner questions that arise as to disclosure. So except for the issue of arbitrator conduct, which I'll deal with last, you can start your analysis of these questions on the basis that the law applicable is well settled. Now, the AFSA rules I've commended to you, they have used the expression which has its origins in the decision in Porter and McGill and the UNCITRAL rules. It's not always been the case that you could look clearly and satisfy yourselves with confidence that these issues have been treated from a historical point of view in a cohesive and sensible manner. It seems to me that looking back upon days gone by, it can be said that arbitrators took a let's get on with it, no nonsense attitude to arbitrator challenges. The best example, as it always is the case, is a real one where in an arbitration in Paris, this was a relationship challenge, not a conduct challenge. It turned out that the female lead counsel for the claimant had been engaged in a rather steamy love affair with the arbitrator for several years prior to the case commencing. That was the only ground of the challenge, and the challenging party reposed some confidence in the success of the appeal and thought, justifiably, I would have thought, that the arbitrator should be recused for that matter. When that aspect, or the central aspect of the claim, was advanced to the judge, with typical Gallic insouciance, simply said, "Quel problème? C'est la vie, n'est-ce pas?" And that was the end of the challenge. Now, one would have thought that a challenge in almost any other country of the world along those lines would succeed. Now, transnational difficulties are a part of the problem which needs to be considered. And let me give you an Australian case and ask you to interrupt me by telling me whether or not this challenge should be accepted. It's a real case called Gascorp and Ellicott, and what had happened was that there were a series of oil and gas arbitrations concerning the oil and gas deposits in the Bass Strait, which separates the mainland of Australia from the island of Tasmania. Mr. Ellicott was counsel for one of the parties in the first arbitration, and he had cross-examined an expert witness for 17 days. And at the end of that cross-examination and during his submissions, he had vigorously criticised those expert witnesses in his written submissions. The criticism was very trenchant. The witnesses were criticised not only for so-called flaws in their methodology, but in relation to matters of the personal approach exhibited during the witnesses' giving evidence. Now then, another arbitration came along some years later in which Mr. Ellicott, a former federal court judge and Solicitor General in Australia, was one of the arbitrators. And in that case, the second arbitration case, the same expert witnesses who had been vigorously criticised by Ellicott in the first arbitration gave evidence in the second arbitration. Now, if nothing more was said about the facts in Gascorp, one would have thought that the challenge might have succeeded, at least if it was mounted east of Calais. Now, can anybody tell me what the result was? I've probably let the cat out of the bag, but Court of Appeal in Melbourne, a very, very good court of considerable repute. Challenge accepted or rejected? Well, the challenge was rejected upon the application of what I call the pure theory of common law litigation, namely that we're all good chaps, we all understand that we have to espouse a particular point of view in a particular case, but that does not make the view our own. It's the argument which we think the client would be able to put if professionally qualified as we think we are. But in this particular case, Mr. Ellicott's previous criticism of those expert witnesses was not held to be a matter which entitled the complainant to succeed in the case. Now, I think I'm getting close, aren't I, Svetlana? Please let me know, and I'll withdraw gracefully. I want to do two things before
Closing works, Bruce. Take
Okay.
1 minute.
Two
Thank
things
you.
before I do that. Firstly, I want to say that the challenges which now fall under the heading of arbitrator conduct are a conglomeration of foolish, churlish, incorrect, bad faith applications designed to achieve one purpose and one person only, and that is to achieve the result that one would normally expect of guerrilla tactics. 4 textbooks have been written on this subject in the last few years, and I want to suggest to you that the subject can be resolved briefly by quickly recognising that arbitrators are not sphinxes, that arbitrators are entitled to ask questions clothed in appropriate language. They are entitled to pleasantly insist upon compliance with time limits. They are entitled to test and to probe the arguments which have been addressed to them by counsel. And indeed, I would go so far as to say that if an arbitrator, during the course of or at the end of a submission, was unclear in his or her mind as to whether or not that submission was flawed or should not be accepted, he or she is under a duty to make sure that before that counsel leaves the room and everyone packs up their bags to fly back to Monte Carlo or wherever, he or she should ask questions which are designed to leave the arbitrator in a position of confidence that she has or he has well understood the submissions and that she can take the next step forward in drafting the award. Finally, Halliburton. Now, when you read it, and you must, because what Lord Hodge and the other members of the Supreme Court in London were purporting to do, and clearly did do, was to set out the law. They took a year to write this judgment, and the law up to about paragraph 159 is first rate, if I may say so with respect. However, after finding that Ken Roberson, who's a very fine fellow, was under a duty of law to disclose his prior appointment in one of the arbitrations which were linked to the club arbitration, under a legal duty to disclose that, didn't disclose it. His failure to disclose the prior concurrent appointment was a breach of that duty. Now, it seems to me, and this is the result of some midnight oil burned by Peter Ashford and I, that once you accept those two propositions, it follows, as night follows day, that the arbitrator should have been recused. Duty to disclose, didn't disclose it, and Halliburton was the only entity who wasn't aware that the arbitrator was an arbitrator in 2 different sets of references. So think about those 2 propositions, and if I could set you a homework task, find the passage in Halliburton which led the court to go the other way. And the answer is, they all thought that Mr. Rogerson was a good chap. And because he wrote a letter to the court and to the parties which said that he was a man of integrity, and because the judges on the Supreme Court thought he was a man of integrity, they then factored that highly subjective proposition back into the equation and said, well, the reasonably informed observer knows that Mr. Rogerson is a good fellow, so let's forget all of the principles that we've just enunciated and reject the appeal. If you think that's right, write to me and try to convince me of your point of view.
Thank you very much, Bruce. Bruce Collins' full paper is available upon request by email, and we will be happy to share. Now, our third but Speaker, Jean-Remy Maistre, the CEO of Just Monday. The floor is yours.
Thank you very much. First, I want to thank you, Svetlana and Michael, for the kind invitation to speak here and to come to South Africa for the very first time for me. So I'm very pleased to discover your country. And I like to start these presentations usually by saying a few words in the official language of the country in which I am. But as you know, South Africa does not have one nor two official languages, but now 12. So instead of ridiculizing myself by saying a few words in 12 different languages that I do not master, I've decided to say something a bit more personal. Before to start Jus Mundi, I used to be an international lawyer, and I was mostly representing governments in front of the International Court of Justice, the ICJ, in The Hague. And as you know, a few months ago, South Africa brought a claim in front of the ICJ because of the situation in Palestine. And I want to say that I'm personally very impressed by what South Africa has done. And I'm not saying that because I believe South Africa is right. It's not my point, and it's not me to say. I'm saying that because this is exactly the type of world in which I believe. A world in which it's possible, even in the worst situations, to bring a claim in front of an independent court. And the ICJ is an independent court, for sure, and to try to obtain justice. That's what we could call one day, perhaps, a global rule of law. And for sure, it's very far away. It's very far from perfect today. But if you look back 100 years ago, we had nothing. So this is already something, and I like to take the time to think of the positive aspect of what we have built the past 100 years ago. And I also believe that in 100 years from today, it will be much better. We will continue collectively to improve this global system and to approach global justice. And this makes me a good transition about what Jus Mundi is about. Powering global justice is the mission of Jus Mundi. And when I say the word mission, it's because Jus Mundi is actually a mission company, which is in France the equivalent of maybe the benefit corporation status that you know. Which means that the mission of Jus Mundi, to make legal information easily accessible to everyone around the world, is incorporated in our bylaws, and as the CEO of the company, I am responsible for pursuing this mission. And we do that, making international legal information accessible through technology and especially artificial intelligence. And that will be the focus of my presentation today. I will first give you a short history of Jus Mundi and how we've been using AI to build this first legal database of international arbitration, and then how today we are using generative AI to enter into a new world of legal research and other aspects. So Jus Mundi is a rather young company, started in 2018, first in Paris. And the difficulty when you want to build a database of especially commercial arbitration is how to collect the data. Because it's scattered all over the world, but in addition to that, most of it is confidential. So how we started for commercial arbitration specifically was to go to the courts all over the world and to collect all the judgments relating to arbitration, enforcement, set aside. And in certain jurisdictions, like the US, it's very easy because it's online. Plus, as you know probably, it's possible also to collect the arbitral award. Once you try to enforce an award in the US, it's not confidential anymore. The award becomes public. But in other jurisdictions, it's much more complicated because there is no online access to legal information, for instance. So we built a first partnership with the International Bar Association, the IBA, to create a collaborative network of lawyers all over the world, helping us to find the award, to find the judgment, and to publish them on the platform. The reason why, or one of the reasons why IBA wanted to collaborate with Jus Mundi, It's because of the mission and because of the open access of the platform. All these award judgments that I'm telling you about are all freely accessible. You can go on Youth-Mundi, access them, download them. You don't need to pay for that. So that was the first step, the first source of information on the platform. The second one that started a bit later was to collaborate with arbitral centers directly and to help them through AI to redact and anonymize the award so they can publish the awards that are legally interesting while preserving confidentiality. And you know, in 2021, the ICC was trying its new rules with an opt-out for publications, and so we did the first institutional partnership with ICC, and that here technology is definitely helpful because, of course, before AI, it was possible to do it manually, and ICA did an amazing work the past 20 years to be able to publish some commercial arbitration awards, but it's limited because it costs a lot and it takes a lot of time. Through technology, we've been able to streamline this process and to publish many more awards. I will show you after some partners of Youth-Mundi today, but we've published almost 10,000 commercial arbitration awards in the past 3-4 years, so it's really a game changer in terms of how we can approach arbitral jurisprudence today and in the future. I will go briefly through the rest of history, but Youth-Mundi has another platform, YouthConnect, which is made for searching arbitrators, counsel, experts, and now secretaries of tribunal as well. We generate profiles based on the caseload of people and based on what we find in the database. We also include publications to complete your search, and more recently, in 2024, we launched the first AI assistant for arbitration, which is not accessible to everyone yet. It's still work in progress. Just a few of our clients are testing at the moment, but I will show you a bit how it works so you can have an idea of where we are going in terms of AI for international legal research. Youth-Mundi today is used by more than 500 clients all over the world. No surprise, most of them are lawyers. You see some of our clients also here on the continent. But the platform is also very much used by governments and companies that are, of course, having a lot of arbitration cases around the planet. Just to finish on this history of Youth-Mundi that the two partners have been telling you about, you can see the network of partners of Youth-Mundi as it is today or as it was yesterday, let's say. And you see partners from all over the world. So there is truly a global movement that we could unlock through AI of arbitral centers or other type of association like the IPBA to help publish more arbitration information. And I know that some people from SHIAC were present just before. I want to thank them specifically because SHIAC is the fourth partner of Youth-Mundi and the very first in Asia. So we developed a very close relationship with them. You see several partners in Africa, in Kigali, Nairobi, Lagos, and Tanzania, plus Corsica, obviously. So that for the quick history of Youth-Mundi and what we've been doing through AI. So basically, to summarize, AI until now, it helps us mostly to collect, process, digitalize, and extract the relevant information from the cases. For instance, from an arbitral award, we extract the number of the rules that are applied, and we can interconnect automatically to the rules. Or we extract the name of the lawyers, and we can create a profile about the lawyers. Okay? So before it was mostly behind the scene. And today, it's different. Today, AI helps you directly to do your work, and I will show you an example. So you might know this case, which is Fraser Solar versus Lesotho. It's a commercial arbitration case which was seated in Johannesburg with South African law applicable, and the rules of arbitration were the AOA NPC rules. We have an award that has been rendered in January 2020, and many follow-on proceedings. And that's through these follow-on proceedings that we could identify the award and the other judgment. And you see that it was contributed through the IBA partnership. One first example of this AI is the possibility to get automatically a summary of the award. Here, the summary is very simple. It just helps you to understand basically what the case is about. So before to read it, you don't start from scratch, you have a basic understanding of the case, of the award here specifically. That's the first Gen AI tool that we developed last year. And now we wanted to go further by creating an assistant that can be much more specific. So here I've prepared, so I'm connected to the case I just told you about, all the documents from the case now, and I'm asking a question to the assistant. The question is, can you summarize the legal proceedings that happen in this case? Actually, I made a mistake, let's see if it works. That happened in this case from the South African court. I don't know, okay. So I want a summary of what happened after. And I will get a summary, and that will be focused on my question, so the follow-on legal proceedings from the South African court. I think there were 3 judgments on several topics that will come up. And I know we discussed for the moot an award generated by GPT. So you know, GPT is one type of AI, and you have very different types of AI. What's the difference, for instance, between GPT and this? GPT first is trying to give you an answer in any case. That's why also it hallucinates a lot, as we said. This AI is trying to give you an answer if it knows the answer. So sometimes it's frustrating. It will tell you, I don't know, I cannot give you this answer. That's the first difference. The second is that it gives you answers only from our database. So if it doesn't find the information in the database, it won't give you an answer. And as you can see, you have sources for the answer, and you can click on one of the sources, and you will get the specific paragraph of the judgment here from which this information comes from. So you can verify for everything if this is correct or not. And of course, AI, I don't want to say AI is perfect, it will, you won't do anything anymore. No, but it will save a lot of time, and you will be able to verify. Sometimes it still makes mistakes, so you have to verify everything. That's the first example, and I want to show you another example, which I believe in international arbitration can change a lot, is the possibility to do the similar type of researches, but in multilingual. Here we have an award from our partner from SHIAC, an award that has been published under the partnership between SHIAC and Youth Moody, so an award that has been anonymized. You see the name of the parties are not present. And this award exists here in Chinese. And I can go similarly in the assistant and ask it to summarize the legal issues in this case. And it picks the answer from the case in Chinese and gives you some information in English. 60 seconds, perfect. I was almost done. And this is for me the most exciting part, because when I was a lawyer, I was so frustrated by my incapacity of reading and understanding legal sources from other jurisdictions. And this is broadening our horizons. And once again, I don't want to pretend that this is perfect, especially when you work multilingual with languages like Chinese and between Chinese and English, because it's very different. There will still be a few months, years of R&D to achieve that, but with the new technologies that we have today, we will get there in a few years. So be prepared. It will change a lot our practice, and I think especially for international arbitration, it will help us to connect and to build this global rule of law. Thank you very much.
Can I ask the first question? Jean-Remy, can you use AI to reliably determine whether or not a particular piece of writing or document that you submit to AI is AI itself or human in origin?
So the answer is no. And it's very interesting because maybe you know the Turing test. Turing made this test like 60 years ago to say, like, in order to know if AI is AI, the test is if a human talks with AI, if a human is not able to realize that he is talking with an AI, it means that AI became intelligent and conscious. which actually was a wrong test. Because today, when you talk with GenAI, with ChatGPT, you might not know that this is an AI, but it doesn't mean that it became intelligent. And this is not intelligent at all. This is mathematics and statistics, that's all. So no, I don't see how we could find that through AI. That's why maybe it becomes an issue to declare when we use AI or not, and especially as arbitral tribunals. I think tribunals should not use AI to decide without declaring. That's personal opinion.
I would like to thank you, our distinguished speakers, Dr. Neil Shersing, Bruce Collins-Kies, and Jean-Remy de Maistre, for sharing their invaluable insight and pioneering perspectives. Thank you very much.
Expedite the proceedings. If you look at your program, you would see that there were to be 2 consecutive plenary sessions. The one was to be hosted, session 4, by the Advocates Group 621 and session 5 by the GCB. What resulting from constructive discussions between the sets of advocates, the solution has been that in the interests of time, we are going to split those 2 sessions, or rather, let me use a better word, we're going to run them together. So we'll treat them as breakaway sessions. And that means that Group 621 will be presenting their session in this room. At the same time, the GCB will be presenting in breakaway room, I think it's breakaway room 2. But no doubt when you're there, you'll see which room it is. So please now make the decision whether you want to attend at mediation, finding real solutions that bind. If so, stay here. Or are you going to listen to the topic, but is it constitutional the legality defense and arbitration, in which case please go across to the venue, I think venue B, I may be wrong. Whatever you do, vote before 2:30. Thank you then. I give the stage to the Advocates Group 621 to present the session, Mediation, Finding the Real Solutions that Bind. Thank you.
Good afternoon, everyone. If you could just bear with us for a couple of minutes, John Bishop is joining online, and we just want him to log in. So,
I think I'm online, Duncan. Can you hear me?
hello, John. Yes, you're on.
Yep.
We can hear you. Thanks.
I'm online. Oh, let's do the hair. Oh, yep.
Right. So now that was a very useful test to see who are the lawyers who look for solutions and who are the lawyers who want to test the legality principle. Because, sorry, let me introduce myself. My name is Duncan Turner. The program says I'm Svetlana Vasileva. I apologize. The session today, well, let me start again. The week this week is focused on arbitration. And arbitration is a process which parties to a dispute give power to a third party, that's the arbitrator, to decide their fate. It's being promoted here because it provides a flexible and efficient solution and an alternative to a court process, which has now gone to room 2, where the state will appoint the person for you. So you either choose a person yourself, or the state will appoint someone to decide your fate. And of course, in each of those processes, legal rules apply to regulate not only the process to be followed, but also the remedy that will be available when the process concludes. In effect, those rules limit the solutions that are available at the end of the process. Often they're binary. You win or you lose. In almost all cases, the relief that may be claimed and the relief that an arbitrator or a court might grant is limited by issues of relevance, limited by a cause of action, limited by causation. Now, we all know that disputes arise from relationships. In the commercial or employment context, they're normally contractual relationships. In the family law or the public law context, they will arise from personal or political relationships. Disputes also arise from car crashes, and we can call those accidental relationships. But when those disputes arise, parties almost always try to resolve the matters themselves by bilateral negotiations. People will talk to each other. In those negotiations, each party has control over his own participation in the process and has control over the result, the remedy that might be used to resolve the dispute. And as we know, many disputes are resolved right there in negotiations. It's when these bilateral negotiations fail that the relationship parties ask the third party arbitrator or judge to intervene, to decide who wins and what remedies should be awarded. In doing so, they hand over not only control of the process to a third party, but they hand over the remedy as well. Ironically, mediation is not considered, either before launching the arbitration proceedings or during the arbitration proceedings. And I'd like you to think about that and to think whether we should be challenging the rationality of that approach. If the party's primary view is that negotiation would deliver the best outcome, and they're prepared to allow a third party to intervene to help them solve that problem, why is there such resistance to appointing a third party to help them progress the negotiations? Why do they need a third party to decide it for them? Because in the mediation, the parties have the benefit of an experienced third party. They have the benefit of legal rules to regulate the process of their engagement, just like in arbitration. But, and this is the big benefit of mediation, they retain the smorgasbord of remedies that is always available to them in negotiations. Mediation provides the sweet spot for dispute resolution. The 2023 CEDAW mediation audit in the United Kingdom found in a survey of 17,000 cases referred to mediation, 72% settled on the day of mediation. A further 20% settled shortly after the mediation day. That's a settlement rate of 92% over 17,000 cases. Now, there is an advanced mediator cohort in that audit, and their settlement rate was 85%. Those are advanced mediators dealing with complex disputes. The Singapore International Mediation Centre's accelerated use of mediation in international disputes, and that center has delivered extraordinary results. With the Singapore Convention on Mediation being signed and ratified in countries all over the world, the enforceability of settlements achieved in mediation are now enforced with greater alacrity and confidence. So before I introduce our speakers today, let me briefly unpack our topic. Finding real solutions that bind. We find solutions in mediation. We don't choose them. They're not binary. We find them. We're not bound to grant or refuse the solutions that are claimed on pleadings. The parties themselves can find remedies that you could never achieve in an arbitral or court process. The solutions are real. In arbitration, you may achieve a damages award, but what if the defendant is insolvent? Are you better served with an arbitration award for money that you will never receive, or by an agreement that the defendant can stay in business and deliver services to you at a reduced rate? The best real solutions are those that add value. They are constructive solutions which can offer value and build relationships. The adversarial processes of litigation and arbitration and the win-lose result is usually destructive. They destroy relationships. And then the last element of the topic is to confirm that real solutions are binding, because there's a far greater likelihood that parties will comply with remedies that they've agreed to in a consensual process than in circumstances where they are foisted with what they consider to be an unfair or unjust result. And now, with the inclusion of the Singapore Convention and mediation provisions in court rules, it's now far easier to enforce a mediation settlement as an order of court than ever before. In our discussion today, we have the privilege of two international guests to discuss the development of mediation in their respective jurisdictions. Mediation has been prevalent in the United Kingdom for many years. the introduction of compulsory mediation in the commercial court rules in the 1990s, when UK practitioners, like South African practitioners, were stuck in their adversarial ways, the introduction forced those practitioners to deal with the process, which is now a widely acclaimed and appreciated one. John Bishop, who joins us from France, was the chairman of Prince & Masons in London, has worked as a disputes practitioner in multiple jurisdictions, including long stints in the People's Republic of China and Dubai. John has a wide experience as a party representative, as a lawyer, as a mediator, and as an adjudicator, and vast experience with complex matters involving multiple cultures. So we're going to welcome John shortly. India has recently indicated its formal intention to embrace mediation by promulgating a new Mediation Act. And we're privileged to have Mr. R. Santhana Krishnan, Santhan as we call him, an honorary life president of the Commonwealth Lawyers Association. Santhan has founded the Navaran Association of Mediators at the Supreme Court of India in Delhi, and he is driving support for mediation in India. Ofense Motlasedi is a colleague of mine at Group 621. She is a young mediator, has conducted a series of commercial mediations recently in Johannesburg, and she will share her insights and experiences that may be relevant and relatable to young practitioners and old practitioners who are starting out as mediators and are keen to make a difference. So without further ado, I'd like John to share his thoughts with us. On screen. There we go.
Thank you very much, Duncan. First of all, can I say how delighted I am to be invited to join this session, and how disappointed I am that I'm not with you in present, but because I so enjoy my visits to South Africa. But I've been asked to give some practical tips on making mediation work in complex disputes. So there are tips, and I've prepared, and I hope you have in front of you, or you're being shown one or two slides. They are tips, and I probably don't have time to go through them all, but I will pick out some points that I think are important. And when we say complex disputes, disputes can be complex, and I have to admit I have a narrow experience because I've worked almost all my career as a construction lawyer. But in my world, disputes can be complex because there are multiple disputes arising from one project, or because they're very technically complicated themselves. But I will say to you, and this is my absolutely firm view, that no dispute is so complex that it cannot be settled by mediation. It's the excuse people often use for not trying, but there is no dispute that is so complex that it cannot be settled by mediation if you set the process up properly. And in fact, what I'd like to suggest to you for resolving disputes, complex disputes, mediation is particularly suitable because it involves various issues which you can now see on screen, I hope. First of all, there's the discipline. The mediator will almost certainly ask you to provide a brief, high-level statement of the issues that are behind the dispute, maybe 30 pages. The discipline of actually taking the complex dispute and reducing it to 30 or 40 pages is of itself a very, very good starting point for the mediation. Then there's the need to explain the case to the mediator in simple terms, and very importantly to the other party. So often disputes we find arise because one party has not really understood the other party's point of view. You will all know, and I don't have to tell you, the importance of the confidentiality roles in a mediation. But that confidentiality allows the mediator to explore by question, by answer, by explanation, the real issues. And that's a chance that is extremely difficult for arbitrators and hardly ever exercised by judges. And so that flexibility allows the real issues to be brought to the attention of the mediator and to the attention of the parties. So the experienced mediator will help identify the key elements and will put in context emotive issues. So many problems arise because of personality issues on projects. And one of the mediator's jobs is perhaps to take that emotive element out. So the first question people always ask is, well, if we're going to have this complex dispute, when should we try and mediate it? My answer is, first of all, sooner rather than later, but sometimes you can be too soon, you can never be too late. I've mediated disputes that actually in the middle of an on-running arbitration or court process. But the question is, are the issues well enough known to each party that that party can evaluate its position? But it's good to get to the mediation, the complex mediation, before the issues escalate. In my world of construction, the disputes on projects escalate and go bigger and bigger. And the sooner you can get to them and start resolving them, the more likely you are to achieve settlements. So an earlier approach may also offer an innovative solution. That's to say that it may allow the mediator to suggest a solution that no judge or arbitrator ever could, but which may commercially work for the parties. And the other thing is, forgiving sooner, that these kinds of complex disputes, the cost elements with barristers, experts, massive disclosures of documents get so out of control, you need to try and therefore get to your settlement before the costs themselves are the issue that prevents settlement because they're such a big issue. As you would expect, it's important to find the right mediator, somebody you're going to have confidence in, somebody who's capable and willing to get into the detail and willing to spend the time to understand the process. From the mediator's point of view, yes, I think the very important issue is there will always be a mediation agreement. I like to keep them short. I avoid expressions like facilitative and evaluative, which are just interesting debates for people working in this area, but are not actually often helpful. I've found that the parties are very often in complex disputes spend a long time trying to resolve the dispute. For a mediator to come along and say, this is your dispute, and I'll try and help you, doesn't work. So some element of private evaluation can be helpful. And ensure that you have the right to say when the mediation isn't working and has to be brought to an end, because you can constantly remind the parties that you have the obligation to tell them when the case isn't going to settle, and you've not yet reached that position. Two essential elements. First of all, I suggest to you for complex disputes, you always need a pre-meeting, and I'm going to come to that in a moment. And secondly, before you get the submissions and so on from the parties, in a complex dispute, I ask the parties to send me all the relevant contemporaneous documents so that I understand them and read them before I even have a pre-meeting. The pre-meeting, as I say, I think is vital. First of all, it's good to have a smaller group because the mediator needs to find an ally or two on each side, one or two people on each side who are actually really interested in achieving settlement, and the pre-meeting is the opportunity. It's the opportunity for the mediator to actually set what the real expectations could be for the mediation of this complex dispute. If it's going to take 2 or 3 sessions, this is the opportunity for the mediator to explain and avoid later frustration. Also, it's the opportunity for the mediator to explain the approach he's intending at that stage and why he wants to go through certain stages, such as the submission stage and very often the site visit stage. Site visits can be very valuable because the parties have to cooperate to show you the things you need to see. And that early cooperation is the first good step towards a settlement. It's the opportunity to make sure the right people are going to come to the meetings. The big bosses on complex disputes usually say, well, I'll stay in the office. Phone me when there's something you think I need to join. You want to get the big boss there from the start and get him engaged in the process. You need to understand, of course, what happens far in the way of an attempt to settle, No point in going back over ground that's already been exhausted. But it's very important to explain at this pre-meeting that a great objective is to make sure that each party really does understand the other's position. And you can also explore at the pre-meeting what the obstacles to settlement have been. Very often, as I said just now, they're the personalities. Sometimes they're the independent profession. In my world, very often the engineer who's been making the decisions. From the mediator's point of view, he has to work out how he can, if necessary, sideline that professional so that the two true parties are discussing it and the engineer is to the side, called on when needed. You can find out who has the responsibility for the deal and what he needs to do. So, for example, I mediated a series of complex disputes for the British government where the problem was everybody was just scared of the Auditor General's investigation. And one was able to say to the parties, right, if that's the problem, then if we get to a deal, I'm ready to come and meet the Auditor General and explain to him why this is a good deal. And another very important, and I don't know if Edwin Glasgow is in the audience, but I know he's with you, he taught me the rule that the mediator can always invite the parties to send their private communications, many things to the mediator, which are not disclosed to the other party at all. All the mediator asks is that it is known that there has been a communication. It enables the mediator to have a real insight very often as to what the true issues, the driving forces for the dispute are, as opposed to what's been stated in writing and in argument. And finally, for this purpose, when you get to the formal meetings, you'll note, unlike anything else, they're never called hearings in my world. I have to say I don't have hearings in dispute boards either. Formal meetings are what they are. It's essential for the mediator to know the issues and demonstrate that he does so. So really an in-depth understanding builds confidence with the parties. The next thing the next tip that I have here for you is the mediator needs to understand and identify who the destabilizers are. There are people, usually in mediations, who actually, because they think they're so definitely right in the position they've taken, they don't want the thing to work at a compromise. They want to be proved right in court or in arbitration. The mediator, the good mediator, will identify those people and find ways of preventing them destabilizing his process. I have had experience when acting for parties of a mediator who said, this is such a complicated dispute, maybe we should just talk about how we could carve up the figures. It may be that's the end result, but I never ever suggest it. As a mediator, you always have to show you're prepared to go through all the detail if needed. So be prepared for the long slog. This may go on for some sessions. Later, if it may be in the panel, we can talk about 1 or 2 examples. I did a big mediation from Asia last year, which, in fact, it was a bit before that, because it was during COVID, which went on for some months of individual sessions. But in the end, an enormously complicated and high-value dispute was able to be settled. If you're going to have and investigate individual parts of the claim, I always say to people, let's try to resolve that alone. Let's summarize where we've got to, where I think we've got to, and we'll park it for later. And my final advice is, for the mediator, never give up. A number of times I've recently resolved a dispute where both parties told me with great confidence that there was no way this could be settled. And we kept on and on and on, and it's settled. And finally, remember that even if, sadly, you're not able to achieve the mediator, this overall settlement, all the elements of this dispute, there's in my experience, always some benefit from the mediation. The benefit may be that you settled some parts of the case, maybe that you found a more effective way of resolving the parts you can't settle than going to court or arbitration. It may be that you actually simplified the issues because your process has made sure that each party really understands what the true issues are, as opposed to all that fluff that goes around them. So those were some immediate tips, Duncan. I hope they're helpful and look forward to discussing them. And I think I've just about got away with my 15 minutes as requested.
You've done very well. Thank you, John. Thank you very much for joining us. Without further ado, I'll ask Santhan to tell us of developments in India.
First of all, thanks to Duncan and AFSA for giving me this opportunity to share some thoughts with you about what's happening in India in the field of mediation. Having heard the previous speakers speaking on the mediation process, let me briefly share with you. During the 1990s, when the economy in India was opening, that led to increased economic activity followed by commercial activity leading to docket explosion. In its 129th report of the Law Commission, and then few other developments around the 90s, a recommendation was made to introduce mediation as one of the dispute resolution mechanism, pursuant to which the Civil Procedure Code 1908 was amended, and it took effect from the year 2002, whereby Section 89 was introduced, where it was incumbent on every district judge, while entertaining a suit, to explore whether there is a possibility or elements of settlement. If so, it is incumbent on the district judge to refer the dispute to an arbitration, a conciliation, or settlement through mediation. That's how the mediation process or ADR process began in India. While experiencing after going through the initial teething troubles, a model mediation rules was formed, and that was adopted by the various high courts. And thereafter, mediation centers started attached to every high court across the country, and thereafter, various districts under the various high courts. In the year 2005, the then Chief Justice of India, through an administrative order, formed a mediation and conciliation project committee. This conciliation project committee, which is called MCPC in short, took up the responsibility of training mediators from across the country, from the various state capitals and also the districts. But in a major way, there are few parts of India where mediation was really taken up very seriously, starting from Delhi onwards, Delhi, Ahmedabad, Mumbai, Bangalore, Chennai, and of course in Kerala also, where mediation was taken up seriously. And then the result of the exercise of mediation so far has been about 30 to 40% of the cases that are referred to mediation are by and large successful. In this process, what happens is, once the court refers a particular case to a mediation, after settlement, it comes back to the court. An order is passed by the court, which becomes a decree, an executable decree. This is the process through which India has been dealing with the field of mediation for almost 2 decades now. While being so, the Arbitration and Conciliation Act 1996 also has a clause through which settlement can be arrived at wherever there is ad hoc mediation outside the court. Besides this, there are a number of enactments. Amendments were brought to number of enactments starting from Family Courts Act, Consumer Protection Act, Companies Act, and few other acts. And thereafter, in the year 2018, the Commercial Courts Act was amended, wherein the pre-litigation mediation was introduced. These were all a build-up and a pressure that was built towards enacting a mediation act which can cover all the areas. Simultaneously, there was also a judgment of Supreme Court which gave a direction asking the central government to consider enacting a mediation act. These developments led to constituting a committee with regard to the framing of the act. It took almost 2 years' time for recommendations to be made by the committee, and formally the Mediation Act 2023 came into being a few months back. The important aspect of the Mediation Act 2023 is all the mediations that were taking place through court-annexed mediations across the country, the mediations that were taking place through various amendments to various enactments, and also the mediations which were ad hoc in nature, where settlement was arrived at under the Arbitration and Conciliation Act 1996, were all brought under one regime, a uniform regime called Indian Mediation Act 2023. There are 2-3 important elements which this act deals with. First of all, it speaks of a mediation service provider and also mediation institutes. The mediation service provider is a setup which can be formed through a voluntary initiative, and they can take up the responsibility of conducting mediations across the country. Similarly, the Act speaks of mediation institutes. A mediation institute can be formed, and they can undertake training the mediators across the country, whereby the dispute resolution through mediation can be, in a major way, take up the responsibility of the pendency of cases across the country. Here, once there is settlement under the Act, it becomes a decree of the court. You don't have to invoke the jurisdiction of any of the courts to make an executable decree. The more important aspect is the Act contemplates a constitution of a Mediation Council of India. The Mediation Council of India takes up the responsibility of regulating the mediation service providers, the mediation institute, and everything under which the mediation can be contemplated, which includes also online mediation. Thanks to COVID, from the year 2020 onwards, as India witnessed, the world across also witnessed, online mediations also taking place. This Act also recognizes the online mediation through which disputes can be settled. When I speak of mediation, it could be a mediation concerning a family matter, a mediation concerning any civil matter, civil disputes, or a mediation that concerns compoundable criminal offenses, and then few other things. So any matter that can be mediated forms part of this particular act, and then the act also gives a time bound within which the mediation has to be successfully completed. It is 120 days, extendable by 60 days thereafter. The fact that this Mediation Act has come into being, but it is yet to take into effect. Once the Mediation Council of India is appointed, from there the Act will come into full force and we would see what happens in this field. Niti Aayog, a planning board in India, said if the pendency of cases which is presently existing in India, if adjudication has to be completed, it will take more than 300 years, which is mind-boggling, but that's the hard reality, which also emphasizes the fact that mediation has to play a major role in the coming years to come, through which the disputes can be settled in a very amicable way, and mediation can play a major role in the dispute settlement mechanism. Yesterday, I heard the Chief Justice of South Africa speaking on, touching upon the fact that Mahatma Gandhi played an important role as to how disputes can be settled through mediation and arbitration. Although we have a formal regime today, but the original author of mediation was in fact Mahatma Gandhi, who spoke about the importance of mediation more than 100 years back. And therefore, I often get to hear from our friends in South Africa that you gave us Gandhi and we gave you back Mahatma. Thank you very much.
Thank you very much, Santan. To those of you who don't know perhaps a little bit of what's happening in South Africa, and then we will have a discussion. Most people will know about the CCMA, our Council in Labour Disputes, where mediation is a central element in trying to resolve every labour dispute. So mediation is ingrained in the culture of dispute resolution and has been for many years. You heard the Chief Justice talk last night of IMSA. IMSA was a central body in the early 1990s that gave people a forum in which to engage where there were serious political differences between them. The Uniform Court rules have been updated in the recent years, and Rule 41, capital A now, requires parties to issue a notice when a new action or application is issued. And parties must indicate whether they agree to or oppose the referral of the matter to mediation. One of the frustrations to mediation practitioners after the introduction of this rule has been the lip service that practitioners pay to that notice. The notice merely says, do you want to go to mediation or not? And the practitioner's role now is to just tick the box and say no and move on. So we're waiting, and the judges are actually in the other room. I was hoping they'd be here because they were going to be up next. Because to challenge the judges and to say to them, when next you get a matter in your trial role or your application role that ought to have been referred to mediation, we'd suggest that the judges issue punitive costs orders for not having done so. Because as soon as there's a consequence, the alternative becomes far more appealing. We know that the Law Commission in South Africa has been looking at a mediation bill for some time. Hopefully, we'll see that bill published during the course of this year. And then, if it passes muster, we will have a mediation act of our own to give impact to the practice of mediation in all disputes. But I'd encourage all practitioners here today to read up on mediation, to perhaps attend the AFSA course, and that will train you in mediation. And tell your friends, encourage your clients, and make mediation an active part of dispute practice. Now, we have the benefit of experience on the stage, and I'd like to ask Ofense to share some of the insights that she's received as a young disputes practitioner exposed to mediation and what the learnings have been that have opened her eyes to mediation as an alternative rather than the adversarial approach. Try this one.
Thank you, Duncan. I'll say, one of the first things that come to mind around mediations and what I've come to learn is that when you initially receive that brief or that instruction or initially interact with a client, the dispute is always framed in, very complicated and large, often insurmountable terms. But through the process of actually sitting down and walking everyone through the steps of a mediation, you often find that there's a simple dispute between two parties or more that would benefit just from a slight shift in perspective.
Have you got an example?
Sure. Let me tell you about a mess I walked into late last year, where I was asked to mediate a dispute involving two employees of a multinational corporation. So this particular department had already experienced resignations. There were allegations of racism made in respect of both parties. There were allegations of no regard for an individual's personal space. There were mental health implications. There was the potential of a PR fallout for this particular company. It was a riot. The attorney had so little faith that this dispute could be mediated that she basically said to me, "You've got 3 or 4 hours. Good luck." They were so sure that it was going to turn into a protracted legal battle that I was basically given a few hours on a Friday morning. To cut a very long story short, we settled because at the heart of that dispute was an employee who wanted the acknowledgement of her superior. And it was also a superior who was facing incredible pressure in a large organization and who wasn't aware of the needs of that particular employee. Yeah.
Thank you. John, you still online?
I am.
Does that sound like a familiar story? And is that a story that you can find in big business when you're on a major construction project?
Well, I'm happy to say nobody's actually said to me that you've got 3 hours. But great congratulations for grabbing the 3-hour challenge and getting a deal. Example, typical in my world, a little while ago was a dispute. There were probably, if I remember rightly, 16 disputes, and 8 or 9 of them turned on major technical issues. But there had clearly been a serious breakdown in communications between the contractor and the engineer, and the employer had backed the engineer at every point. But we were able to, over a series of sessions of which presentations were made, and of which I then had private meetings with the parties, we were able to see where the personality problems came in. We could see where there was a real dispute or where there was a way of actually overcoming the technical problem that was still ongoing at the time. And we managed to break it down, and in the end, we came to a settlement with a sum of money passing hands, but mainly by finding practical solutions to the technical problems that the parties were facing. But we did it by managing to, frankly, put to one side the engineer and a couple of other parties who were preventing the settlement and who were causing the problem. So it was a matter of, yes, a lot of late night reading, understanding the detail, but gosh, and it probably did cost quite a lot of money, that mediation. But we were heading for an arbitration which, when I asked the parties, both parties agreed looked like 4 years to prepare and get going, and probably in all 2, 3, or even 4 months of hearings. So one was able to point out that the settlement that was able to be achieved wouldn't have been able to be achieved in that arbitration, and the mediation cost, which I understood from the parties was something well under 10% of what they would have spent on that arbitration, probably 5%.
Thank you. I'll come to Santan now, but I think what a lot of practitioners underestimate is the emotion that fuels litigation, and how that, until that emotional bubble has been burst, clients insist on their day in court. And the remarkable thing is the distinction between what a lawyer considers a day in court and what a member of the public considers a day in court. Because the lawyer wants the judge on the bench, wants the other side's heads of argument in front of them. They have a very clear idea of what a court is. But my experience is that most laymen don't. They just want a third party in the room to hear their complaint. And once that complaint has been aired, with the other side of the room perhaps, and a third party to listen, that is their day in court. And once their position has been ventilated, they've got that emotional outburst off their chest, rationality and reasonableness can come back into play. It is an extraordinary cathartic process for a client to finally get the opportunity to tell the person on the other side how much they upset them. Putting legal rights aside, how much you upset me, how angry you made me, how much you upset my organization. And having got that off their chest, they're ready to talk. And so as litigation lawyers, particularly those close to the client, the attorneys, they often get caught up in that emotion. They get caught up in the intractable force of that emotion that's coming from the client, and they buy in, and they drive the matter. And I'd encourage you to just sit back when you've got a client like that, take a deep breath and say, well, what would happen if this client gets an opportunity to complain, to express that frustration? Would we then be able to get the wheels turning? Santan, finally, before we wrap up and try and get everyone off to lunch, how have you've heard Ofense's explanation of her example and John's idea of the complex one. Do you have an example from the Indian context where you've seen mediation work where nobody else thought it could?
I'll give you one example. A person had 2 wives, and from their two wives, 2 sons were there. This man was a rich man doing some business, and the fight went on with regard to their respective rights over their respective properties. Fight went on through various courts of law. Nothing resulted, excepting the fight going on and on and on, from the topmost court to the bottommost court, and then back and forth. Ultimately, when this matter was referred to mediation, there were 2 mediators sitting in the room. After discussing with these 2 sons with regard to their problems, both the mediators stuck with an idea. They said, we will get a coffee into the room, and then in the name of having coffee, both the mediators slipped out of the room. They were outside the room for about half an hour, and then they came back. When they came back inside the room, they were surprised. Both the brothers were embracing with each other and then crying as to what happened all over the years. And the matter was settled. And I don't think there can be a better example than this. It was a risky affair. They could have up in arms fighting with you. That was also possible. But the mediators, after conferring among themselves, decided to step out of the room and then come back after some time. And this is what they saw. And the matter was settled.
That's a lovely story. And I've heard it so many times. One of our senior colleagues who does a lot said, two partners who'd started a business together, who had built up this wonderful property empire. Their children had a falling out, and they had a falling out, and then they were in litigation for years. And he said, after a day in mediation, they embraced, they cried, and they walked off through the parking lot with their sort of arm in arm. All they had to do was remind themselves of who they were when they started the business and why they did it. And so never underestimate the emotion that sits behind every case. Whether it's a commercial case or a family matter, there is always emotion. And if you can get that emotion out of the process, you can almost always find a rational answer. We have actually managed our time very well, and we've got time for questions. Mediation is that one area where there may be lots of questions. So is there anyone in the audience that has a question for John, for Santhan, for Ofense, or for me? Is everybody ready for lunch? Well, then without further ado, I can't see any hands. John, thank you so much for joining us all the way from France.
My pleasure.
Santhan, for joining us on stage. You were a very welcome guest. Justice Rao is here as a mediator now, having come off the bench. And to Ofense, thank you very much. Thanks a lot.
May I have your attention, please? Please be seated. Please come to the podium. As we come to the close of the 3 days of JOY 2024, I would like us to just reflect on the key takeaways. The conference was a great success. We've learned about a whole lot of issues, insightful debates, but one of the key milestones, one of the key achievements here, no doubt, was the adoption and the signature of the AFSA Alliance Charter. It was a great success and a milestone indeed. We've also heard about continental issues, about the African Continental Free Trade Agreement and the investment protocols being developed thereunder. Very insightful as well. We've heard about CAGEC and the rules of CAGEC and how those will form the foundation of the BRICS Arbitration Center rules. Quite insightful indeed. Without further ado, allow me to please hand over to our youngsters, young AFSA, to make an announcement in relation to the man or machine debate. It's over to you. Thank you.
Hello, everyone. Go first.
Hi, everyone. Thank you very much. I'm Jonathan Barnes, a partner at Bowman's, and I'm here with...
I'm Kirsten Volmerans, also a partner at Weber Wenzel. So we are here representing Young AFSA and the very sticky question of man versus machine. I think just to summarize all of the wonderful sessions that we had dealing with this topic, I think it's very clear that we are at the forefront of an ongoing debate, which is the role of human arbitrators versus the AI counterparts. This has captured the minds of across industries, from law to tech, and it's one that carries profound implications for the future of dispute resolution. So on the one hand, human arbitrators bring to the table a wealth of experience. We have empathy, we have nuanced judgment, which is honed over years of experience and practice. One would say that humans can navigate complex legal frameworks whilst considering the intricacies of human emotion and context. Our decisions are also imbued with the understanding of the parties involved and the broader societal implications of their rulings. At least we hope this is the case.
Conversely, AI arbitrators offer a tantalizing promise of efficiency, consistency, and impartiality. They're powered by sophisticated algorithms and vast data sets that can swiftly analyze cases and identify patterns. And some would argue that they can render decisions that have a level of precision that may surpass human capabilities. As the representatives of Young AFSA, we are especially interested in this topic. Young practitioners play a crucial role in integrating AI into arbitration and bringing fresh perspectives and technological fluency to the table. Our enthusiasm for innovation drives our exploration of AI tools and enhancing efficiency. So having said this, we want to thank everyone who participated in the moot and in the big debate as to whether or not it's man versus machine. And we want to now give you the results of the questionnaire. So 4 main questions were asked. You will have seen that there were 2 awards, Award A and Award B. The first question was, which award did the humans write? 70% of the votees said that Award A was written by humans, and 30% said that it was Award B. The award that was written by humans was indeed Award A, so 2/3 at least in excess were correct.
But arguably it goes downhill from here. The next question is, which award was the correct award? So, Award A, which is the human written award, only 54% of you said that this award was correct, which leaves 46% saying, actually no.
And then we asked, could the results have gone either way? And it was an equal 50-50 split of people saying yes and no.
And now for the most, I'm going to ask our representatives, the custodians of the machine versus the custodians of mankind, to defend their honors with this next question. The question was, do considerations of speed and costs override the human touch? It was a landslide. It was 80% in favor of yes, speed and cost outweighs and overrides the human touch.
So we're interested to hear the views of Elsa B. and Pat Lane on this, and we welcome them to take the stage and give us their insights and thoughts.
Thank you.
Well, first of all, let me tell you that I was part of the human team. I think I'd really want to comment on this concept of speed and efficiency. One has to be very careful to sacrifice justice to speed and efficiency. And what people have got to think about is if you're using an AI platform, where's your protection? Where's the data protection? One of the core principles of arbitration is privacy and the right to have a private dispute resolution process. And with data protection, there is no answer to that at this stage. There's no answer that you will not be, that whatever the award is or whatever is put onto that platform is not accessible by a third party. I mean, I've seen that in many walks of life. In fact, yesterday was one of the questions I posed in another seminar, and that was, how do you actually protect the data and the awards? And the answer is we don't, and we don't want to have our awards because we can't, but the benefit of the, what they call the robotic world or the world is data collection and use as distinct from awards writing itself. So I have to say I find the percentage quite surprising as far as the preference, because but what it does indicate, and I'll talk now on the positive side of things, is that arbitration, it has and will continue to look in the human world for areas where arbitration can become more efficient, and we are evolving principles and practices which combine civil law and common law principles and practices which go to the speed and efficiency by which the human award can be made, and there we can offer data protection. So those are just very brief comments on the vote. Thank you.
Good afternoon again, everyone. On Tuesday, it was very late when we did this exercise, but I think it was good fun. And personally, I'm quite pleased to see the results, to see that it was kind of balanced, that, you know, the University of Pretoria generated the AI award, did not completely lose, because we don't like to lose. So thank you again, Michael, for giving us this opportunity. We've also worked very closely with Young AFSA, which was a real pleasure, so thank you also to you. As you know, I'm too old to be a Young AFSA, but it's always good to be energized by the young people. I think this is also a good lesson, maybe the start of new collaborations in order to determine exactly how do we use AI. We've seen that an award can be generated within a matter of minutes. And as you've told us now, it wasn't complete nonsense. So I think the trick will really be in combining the two. You know, we know that you can't blame the computer for everything that goes wrong, because there's still a human being that puts in everything into the computer. So it depends a lot on the type of questions you ask AI. ChatGPT-4, this was the version we used, it's the pay version. So it depends on the questions. You have to put in the right questions in order to get the answers that you want. And so I think it will depend on how we use AI. I think what is very important to realize is that there is no longer the option not to use it or to ignore it. As you may know, I'm affiliated to the university, and when ChatGPT first came to the fore, parents called me up and asked me whether we were going to ban this in our law faculty. And I said, it's impossible. It's already there. When you go into Microsoft, you will get Copilot. AI is everywhere. I mean, predictive text, we all do that as well. So this is yet another step. And I hope that it has at least ignited or sparked interest in how this can help us. But very importantly, we must remain human. We talked about that. I think that's one of the most important qualities that we also want to instill in our graduates at the university is to retain that sense of humanity. For lawyers, interpersonal relations, your social relations, those are really, really important qualities and attributes. And so to conclude on this, I think this was a great exercise for us as well, with quite surprising results. But I want to emphasize that we should always show up and be human. Thank you.
Thank you. What a result. Now, may I invite the co-vice chair of AFSA, Patrick Lane, to come and make the announcement of the winning team.
Thank you, Lindy. I'd first of all like to make a few comments about the mood. First of all, I'd like to congratulate all three teams. You really put a marvelous effort in producing your arguments. It was a very difficult decision for us to make as the panel as to who won this moot. But just as a few comments that I'd like to share with you as to where the tribunal felt about the presentations. It seemed to us that all three teams, and this is just a question of advocacy, had devised their plot. They had learnt a script. And so when it came to the tribunal asking questions in a chess clock environment, they weren't prepared to go beyond the plot. And it's very important from the advocacy perspective to understand that the questions that are being asked are there to help the parties. They're there to direct them. They're there to maybe solve a problem which the tribunal has. And bear in mind, when you're dealing with a chess clock type arbitration and you have only 20 minutes, one has to listen very carefully to those questions, because they will tell you a lot about the way the tribunal is thinking and how best to use your 20 minutes or your chess clock time. So I felt that it's something from an advocacy point of view that would be a lesson to learn. The other aspect of it is that most of the presentations were based upon the written submissions. Now, the written submissions, you must assume that the tribunal has read those submissions. It doesn't need the submissions to be read again or pinpointed in any particular respect. What the tribunal is wanting is new material. They're wanting to know why you say your opponents are wrong, not why you say you're right. Because we know what you say about being right. And again, we saw that there was the preponderance of, and all three teams, was to defend a position rather than prosecute a position. And that was just 2 points of advocacy which I'd like to share with you. It's not criticism, this is something which one learns over years, appearing before many different judges and many different arbitrators. But then came the very difficult task that we had to debate. And this now, the winner of the moot is the aft team. Can you call them up?
Sure. Congratulations are in order to the winning team, the aft team. A round of applause, please. I'm going to mention the names of the members of the team. When we call your name, would you please come up to collect your certificate, please? Ms. Buhle Likokotla, would you please approach? Mr. Camille Premade, please. Is Mr. Camille present? Very well. In that event, we'll move to the next one. Mr. Tabang Matopo, please, would you please approach? What are we going to do with this certificate? Ms. Fuzipe Nako, in absentia. Very well, we shall confer in absentia. Should I give them to you? Maybe we should give them to the leader. I think we should. Yes, we'll give them to the leader of the team. Thank you. Thank you, Ms. Likokotla. Of us three.
We just got one more to do, so let's just finish them.
Ms. Kitumetsi Mashishi. In absentia. Mr. Sichaba Mohapi.
Please wait here. Come up.
Congratulations, I know them, madam. Well done, well done, well done, well done. Very well done.
Good presentation.
Congratulations, well done.
Very well done. And carry on the good work. Okay.
Thank you. May I invite Petlin yet again, together with our Frenchman friend, Jean-Remy Demastre. Please, would you come forward to address projects going forward? Thank you.
Thank you very much for this second opportunity to address the audience. And I am very pleased and honored by what I am about to announce. If you were there in the first presentation, you know that Jus Mundi's goal is to make international legal information accessible to all, and by that we mean all legal information accessible to all. We've been having discussions with AFSA the past months and years, and we are very happy to announce today that we came to an agreement to form a partnership between AFSA and Jus Mundi in order to publish, to first anonymize, redact, and publish with parties agreement award of AFSA on Jus Mundi, more specifically award of AFSA International first. That will be the first focus of the partnership, but we also open the possibility to publish more awards from domestic awards, SADC award, etc., etc., that you will find in the coming weeks appearing on the platform in open access. I repeat also this information if you were not there before. Jus Mundi is open access, so all these awards are accessible directly for free. There are more than 200,000 people every month visiting Jus Mundi, many students from all over the world accessing this information to train themselves. So this award will be available to the largest, and it will show to the rest of the world the real value of the work which is made here in South Africa, because you have one of the best institutions in the world, and it's important to show it and to make it accessible to all. So I'm very, very pleased about this partnership. I thank you so much for your welcome here. It means a lot to us. We know that this is an important step, that you didn't take this decision lightly, that it means that you put some trust in us, and I can tell you that we will be at the level of your trust, and that you won't regret it. So thank you again for your trust and for this invitation of talking here. Before, one point about, because we've been talking about AI and the impact of AI on our work, on arbitration, on the life of counsel and arbitrators. And we have in front of us a lot of changes that will happen through AI, but there are also a lot of big philosophical questions that we need to ask ourselves about how we want dispute resolution to be conducted in the future. You've seen that with ChatGPT it was not that easy to see if the award was real or not. You've seen maybe the AI of Jus Mundi before. I can tell you that if we do the same exercise with use AI, it will be even more complicated to differentiate. But does it mean that we should use AI for decision making? I mean, you can think what you want. For me, it's no. Decision making is human. The creativity, the decision aspect of creativity is human, and this is what we want. AI is just meant to simplify some work, but we have to stay on top of it. We have to be able to understand, to challenge it, to understand the bias, because all AIs are biased, all AIs are biased. So that's a very important message that I wanted to do. And indeed, privacy, confidentiality is super important. When you use such a platform, you have to make sure that it is confidential and it will stay. Once again, thank you, and I hope to have further discussion with you on this topic in the future.
Well, together with that, we have another exciting move, which is also going to progress AFSA, its transparency, and the significance of AFSA in the SADC region. We concluded an agreement this week with ICA to publish what we refer to as the Foreign Domestic Awards. So the SADC awards, which are between two SADC, will be now published by ICA. And this is, of course, terribly important from our perspective, that, and I'm really repeating what has been said already, is that it puts the personality of AFSA, its excellence, and its ability to administer appropriately international arbitrations very much on the global map. And we welcome both of these institutions into the AFSA world. Well, it should be the other way around. In the AFSA joining their world, and through them, global recognition. So it is a very significant move on both behalves. Thank you.
Now, ladies and gentlemen, thank you. Thanks, gentlemen. If I may invite you to take the time at your leisure, please, to go to the website of the JAW, where you will find there uploaded a message of support from our friends in China, People's Republic of China, Guangzhou Arbitration Center. Whenever it's convenient, please, if you could have regard to that. Now, the last item, of course, is a very important item, emotive to a certain extent, because it's an item that requires of me to invite none other than Michael Cooper SC. When I'm happy, I call him Michael the Great. But today I'm being serious. Michael Cooper SC. Before I invite you to the podium, ladies and gentlemen, would you please rise and give Michael a round of applause for the sterling work that he has done in providing wisdom, leadership, to get us to where we are this afternoon. Michael Cooper, the Great, over to you.
Thanks so much. I'm not sure I am as horrified as you are by the results of your votes, because Elsabe, in a sort of wounded way, said, well, we'll have to think about these results. So I thought about the results. And I thought to myself, I have a laptop, which for reasons I don't understand, I call George. When the question arises of the next JAW event, I'm going to say, George, would you invite a couple of your mates and we'll have a JAW? And George will say to me after 3 seconds, 4 seconds, George will say, I have invited 600,000 machines across the world. And I will say, George, there's a splendidly eminent machine in the University of Pretoria. Have you invited that one? And George will say, please, I've invited every machine on the face of the earth. It's going to cost you nothing. You can hire not the Sandton Convention Centre. You don't have to hire anything. And it'll cost you nothing. And I said, well, George, if you look at the program we ran last time, it ran for 3 days. How long is it going to take you to run it? And George will say it'll take 17 seconds. So I see opportunities in the next organization of JAW. I also must say, in defense of humanity, that the moot question was drawn deliberately and specifically to avoid any conflict of fact, any issue of credibility, any question of nuance. And so I think it might be an outlier with an outlier result. But nonetheless, it's an important insight into what we think our other humans will choose. Moving on, where are we going to go from here? There was a debate as to whether we were ready to hold jaw, whether the times we had to prepare for jaw would be sufficient, whether there would be an uptake of involvement. Well, I think all those questions have been put to rest. I think if a country as far away geographically as we are from the rest of the world can, without difficulty, have 400 delegates attend, and delegates from all over the world as well, we're more than ready to hold jaw. We must hold jaw. We were right to hold jaw. It's far too long that we have remained silent when we should have been showcasing what was happening. And I'm certain that the rolling effects of jaw are going to be appreciable, not only locally, but internationally. So yes, there will indeed be another jaw. Whether it will be in a year or whether it will be in 2 years, no doubt our co-hosts and ourselves will come to a decision. But the time between now and the next jaw, we are going to spend on the initiatives that were raised here. The SADC Alliance, to my mind, is a fundamentally constructive and valuable initiative which must be pursued. I have no illusion at all about the effort, the time, the ups and the downs that the initiative is going to involve us all in. I also have no doubt at all that every minute of it will be the most valuable contribution that we can make to the welfare and the development of the SADC communities. I also think that if we can make a success of it, we will be able to enlarge those law societies and legal communities, wherever they may be, who want to join in it. So, yes, if you want to know what AFSA will be doing, it will be working on the SADC initiative. We will be working on Young AFSA and what Young AFSA can do and benefit all the young practitioners here in SADC, in Africa, internationally. I grew up at a time, and many of you are the same, where our perspectives were entirely local. None of us had appeared in the courts of our next-door neighbors, except perhaps what was then Rhodesia and Zimbabwe, what was Northern Rhodesia, but that was a rarity. There was no communication at all. This generation is going to grow up and practice law on a regional basis with a strong international element. I envy them, and it is our task to ensure that we maximize their opportunities. They must go forward. They must be motivated with the same motivations, but with a far broader canvas than ever we had to work with. And we will go on. We will go on adapting arbitration in the various ways which suggest themselves to us, in the various ways we will learn from others who are heavily involved elsewhere in the world with these kinds of modifications and improvements, and from time to time we will do things that are unique. And in all of it, I hope we will have a sense of fun and a sense of achievement. I have one final request to make of all of you. We would benefit immensely if you would take the time in a day or two to write to us and to tell us how we could improve on the presentation of Jaw, what we could do better and what else we might do, because this is the first of what is going to be an ongoing series. And if you could also let us know what other constructive efforts we could make to improve the practice of arbitration, to improve your involvement in arbitration, and to carry the AFSA flag highly and proudly until we meet again. Thank you. Thank you.
Thank you, Michael. And once again, ladies and gentlemen, thank you for your contribution in making Jaw 2024 a huge success. Would you have your safe travels back home until we meet again? Thank you.